Chaudhary, I'm sorry, I have not been able to deliver your transfer judgment.
Okay.
It's coming next week.
My lord, item number 1 and 2, my lord. Under compelling circumstances, I'm making this, my lord, prayer. If only for 1 day, actually this matter was hard, my lord. That's the reserve for.
Problem is, let me take it up. I can't adjourn any of these matters. If-
Only thing, my lord, my difficulty is I could not face. Actually, my lord, the instructing council also has become. So some difficulties were there, my lord. Only till Monday, my lord. Eventually, we could release the file this morning. Monday, my lord.
No, we do one thing, we'll try our luck at 2 and then we will adjourn it for till Monday.
Okay.
Because otherwise it doesn't look nice.
My lord, not at 2, slightly little later, my lord. Second half.
Second.
Yes. Eventually, we trace the file, my lord, this morning only.
Yes.
This is a hard, my lord, but anyway, my lord.
The 2016 matter.
Correct. Actually, my lord, we did our part, my lord. But then anyway, it is, we have to again do our part. Please, your lordship.
This matter may be finally released on Monday. This is a transfer matter because he'll be released on 31st. He's a physically handicapped, having artificial leg, my lord. So that my lord.
You have filed it today?
Yes, my lord. Today I have filed it, my lord.
When?
Today morning, my lord.
Okay, we'll take it up at 2.
Today, my lord.
Please, your lordship. Lordship, I'd like to mention item number 53 of this column. I'm for the respondent. Petitioner, they filed an IA
50?
53.
Yes.
They filed an IA seeking extension of time to comply with your lordship judgment. In the meantime, I had filed a contempt. May I pray that the matter may be listed in this Wednesday along with the contempt.
But I don't know whether the contempt I can direct it to be listed before this court. Contempt jurisdiction is specifically before the Chief Justice. Hey, so we'll take it up.
There's a upgraded item here.
Yes, we'll upgrade it. 53 upgrade it.
This is for listing of items pertaining to transfer.
They've been transferred.
No, they will be releasing on 31st.
They will be
Releasing on 31st of May.
retiring.
So releasing from the present post.
Motion.
Yes, Lord.
We have filed it.
Yes, sir.
We'll take it up today.
Sir,
Then there is no urgency. Monday, why?
Lordship, the matters are, the records are in the chamber.
So it will only happen at 2. I hope you don't stay outside the territory of the Greater Guwahati also. Not on Monday. Then obviously it will be listed. Why should I give you a commission? It will be listed. Pick it up. Yes.
With Lordship permission, Lordship, I would like to mention item number 45, Lordship. There is some difficulty today, Lordship. If Lordship may allow to adjourn the matter.
Okay.
Next
When?
Next week, Lordship.
No.
Thank you.
Item number 45, Miss M. Nirola, the learned counsel appearing on behalf of the petitioner, seeks an adjournment. Matter to be listed after 4 weeks. Yes, madam.
Yes, my lord. Similar prayer, my lord. Item number 23, my lord. It will be taken up on Monday, my lord.
No Monday
Because
business.
by mistake, I have got a wrong
Sorry, no Monday business. Oh, 2018 matter. We'll take it up.
Monday, my lord.
No. We'll take it up today. No Monday
And
business.
as a last item, my lord.
No adjournment. No adjournment in 2018
Last
matters.
item, my lord.
Sorry. We can at best accommodate you in the second half.
Yes, my lord.
Second half. But no
As
adjournment.
last item, so that
No.
I can collect the file, my lord.
Okay.
From Beltala, my lord.
Beltola is not far off.
Because of the traffic, my lord, it may take time.
Okay, we'll see.
This case is mentioned for listing. I am the first wife of my husband. My husband is dead.
Pension is not given to me,
Motion, admission,
no lordship. So
nothing.
listing on 30
For what?
orders, for orders.
Orders. Orders, we'll have it on 14th of June. Yes, ma'am.
Lordship, an unusual prayer for your lordship, your lordship may perhaps recollect that matter where your lordship had set the commission.
Oh,
I
that
had-
matter.
Yes, your lordship. In that matter, what has happened is my learned friend Mr. B. Gogoi has informed me that one of the members of the commission has had a fall and he is having some emergency surgery, so he will not be able to take up the matter. Already 1.5 months has already lapsed, your lordship. In fact, the report was supposed to be submitted on 15th of June. The matter is accordingly fixed on 15th, but then lordship, the commission hasn't even sat as yet. May I pray the matter be listed sometime next week? as
We'll have it on Monday.
Lordships, I'm deeply obliged.
You just, Mr. Gogoi is aware of it
I've already spoken to
So
him.
we'll
He's
have
aware that I'll be
change-
making this mention today. Your
on Monday.
Lordship, I'm deeply obliged. I'm giving the mention. Lordship, also in respect of item number 43, Lordship, it's not there in the updated matters. There was some urgency Lordship had taken up.
What is that matter?
Lordship, this is with regard to the pension, invalid pension.
Oh, invalid.
Yes, Your Lordship. Perhaps if it could be taken up at 2 o'clock. Your Lordship.
Okay, upgrade it.
Deeply obliged.
One and two second. After. And number 3. Yeah. but- एयर कंडीशन रूम में तो जदी पानी आवाज सुने की दाव
May I please, your lordship?
Yes, what is this matter about? Looks like an old matter.
No conflict motion matter.
Anything remains?
Yes, ma'am.
Yes, lordship.
My
What do you
lord,
mean?
what happened, my lord? There is a stay order passed by this honorable court, my lord.
We vacated?
Yes, ma'am. And my lord, due to this, my lord, since
What is this no confidence business? Why you have filed the petition, Mr. Counsel?
Lordship, I'm the president and against me
You are the president,
of the Gaon Panchayat, lordship.
then
Then they have asked a resolution for,
on the 15-day notice,
yes, lordship.
you have got that 15-day notice?
Lordship, first, they have called for a meeting, the date was not took place. Thereafter, again, they have called for the meeting and lordship, they have resolved the resolution, but there is no secret ballot. That is the ground. To adopt the resolution, there should be secret ballot.
my lord, the main ground is that secret ballot is not maintained, my lord. My lord, but I have filed the affidavit by stating that all the members were called one by one. They have handed over the ballot and then they have put their, whatever the initial sign is there, then they have put in a box, then it is counted. But lordship may kindly peruse the record, my lord. That is the
Only the ground is secret ballot.
secret. And the one thing is, another, they have taken the ground that, my lord, before the resolution taken, there is another meeting, my lord. So they want to say that there are 2 meetings, but what happened, my lord, the earlier meeting was with regard to how the procedure will be followed while the no confidence motion will be taken up, my lord. If lordship may come to the, my lord,
Show me the impugn order. Where is it?
my lord, the resolution, lordship may come to page 44, my lord. The resolution.
Today on so and so at 11 AM, the second meeting was held on the for no confidence. Today, the secretary thereafter, President Iman expressed his view. Allegations were that secondly, she approved the president had submitted to final support against the allegation. Thereafter, the word expressed that they do not have any confidence upon it. Telangana Governor, who was present in the meeting, declared the results of the voting in front of the she found that 7 members cast their vote in favor of the no confidence motion. 1 member cast their vote against the no confidence. As they were not satisfied with the definition, that's seven. Then we do the-
No, we had a condition. It's minutes. If I get resolution for the resolution, please. Something, please.
Yes, tell me.
Page 44.
I've read it. What case you have? No case. There were total 9 members present. Of the 9 members, 7 are against you. By way of a stay, you have enjoyed a lot.
Yes.
Matter is over. Nothing remains.
Kindly pass over timing my senior.
Who is senior? This is item number 3.
Yes,
Who-
sir.
Who is the senior?
Mr. TJ Mohandas. TJ Mohandas.
Where is he?
He's in Lakes.
You don't have a case. Get him. I won't dismiss it on your face. You have the records, get it. Before the end of the top of the list, this
As
court
far as
can't
the
keep on
records are
waiting.
concerned, Malad, I don't have those records, relevant records, but the client, the council has been saying, as far the voting is concerned, I have the other report. I don't have the ballot papers.
I don't require the ballot. Whether there was a secret voting or not.
Even the copy of the resolution is not there.
In the affidavit also they have did not deny that there was a secret. They said that the ballot paper were submitted not in the ballot box but in a folded.
So that
manner.
is enough.
That's enough.
What else is required? You want a box for 9 people. Who is going to spend the money for that? Next. Ask your senior to come.
5 and 6.
5, 6 and 7 probably, my lord.
5, 6 and 7.
3 matters.
Yes, what are these matters, Mr.?
My lord, matter is, my lord, eviction notice from railway land.
And
My lord, I am there from since 1974. My lord, the notice was issued by the state office, stated to the state officer from Tinsukia, and the property is situated at Dibrugarh, Naliapul area. My lord, proceeding was held at Tinsukia. My lord, as per section 3, my lord, local limits of the of the property where the subject matter is situated. So, my lord, my submission will be this, my lord, Tinsukia has no jurisdiction. The proceeding should have been held at Dibrugarh.
who has done that?
And
The estate officer.
State officer
Does the estate officer has a seat out there in Dibrugarh?
at Tinsukia.
Then where is he going to do? How many? You can't have a district-wise estate officer. The estate officer may be one also. The estate officer may be for lower Assam division, upper Assam division, there might be one also.
But here,
Is it the mandate of the public, this particular act? The, what is that? Public?
Premises eviction of unauthorized. occupants.
Yes, that is the trump card of the railways. So this particular act, is it mandate that for each district there has to be an estate officer?
it is not, my lord. The
Tell me, for the purpose of police, how many estate officers are there? 1. Then are you going to say that the district concerned didn't have an estate officer? If it is your case that yes, there is an estate officer in Dibrugarh, well and fine. Otherwise, you don't have a case. And why haven't you gone and filed an appeal against that?
well, here in this case, your lordship kindly see, my lord, it's the notice state only the state officer. We do not know what is his designation. The divisional engineer.
Then
should
it
be
is
the
much
state-
better for them if they don't have that. Have you submitted your reply or not?
Yes.
My lord, I submitted my reply. I'm not-
So you know where.
No,
Okay, then
not appeal.
what happened?
Then, my lord, the order was passed.
Then why haven't you filed appeal?
My lord, appeal.
There's a statutory appeal under the, before the district judge?
My lord, I filed this petition.
No.
My lord.
I'll give you time. File your appeal, whatever may be.
That too after 4 years, my lord. He has approached this. The eviction order was passed in the year 2017. The writ
Oh.
petition is filed in
They
2013.
were not taking any
2021.
steps. My lord. We thought that it has been.
They must have forgotten.
My lord, were the poor.
Serious
poor
delay and
persons, my
laches,
lord.
my lord.
I will only allow you to file an appeal subject to the period from the date of filing of the writ petition till date shall be excluded. Earlier period you have to explain.
And for some days, my lord, there may not be any coercive action for my protection. My lord.
Why?
In the meantime, they.
You have already enjoyed a lot.
If
There
they
was
are-
a stay, I
in the
suppose.
mean-
No,
if
no,
in
there
the
was no
meantime
stay
they are
order.
Then haven't you vacated
Well,
him?
the honorable court had verbally informed me, well, asked me not to take any action till disposal, so we had not. As such, there is no order, my lord.
So there is no stay, then no problem, they won't do anything.
My lord.
Why should this court think about that? If there is anything out there, then you have the power to restore it also. Heard Mr. KK Day, the learned counsel appearing on behalf of the petitioner, Mr. B. Sharma, public premises act. Mr. B. Sharma, the learned standing counsel for the railways. The common adjudication is being made in respect to these three writ petitions, having regard to the contextual semblance of facts and the legal issues involved in this present writ petitions. The petitioners herein have challenged the notice dated 11/4/2000, all cases
Final order, my lord.
Not
Final
the
order.
notice, my
have
lord.
challenged the order dated 24/11/2017. In all cases, same order passed by the respondent number 3, estate officer Tinsukia. In eviction case number, is the case number different?
The case numbers are different.
In eviction case number EO/TSK/land/556/2017, comma, এইকেইটা আৰু দুটা নম্বৰ দি দিব হা, প্ৰেয়াৰ পোৰ্চনত দেখা। Mr. Day, what do you want? The moment I exercise the jurisdiction, I dismiss it. If you say that you want to file an appeal, it is okay.
My lord.
That is better,
That
because otherwise I'll have to deal with it and say,
is better.
the learned counsel for a petitioner submitted that against such an order passed under section 5 of the Public Premises bracket Eviction of Unauthorized Occupants Act to 1971,
Section 9.
an appeal lies before the district judge of the district in which the public premises are situated in terms with section 9 of the said act. Taking into account in that view of the matter, the learned counsel appearing on behalf of the petitioner submits that it was on a mistaken advice that the writ petitions were filed before this court without resorting to the remedy as available under the said under section 9 of the Act of 1971. He therefore submits that he may be permitted to withdraw the instant writ petition and be given the liberty to file appeal under section 9 of the Act of 1971. And as the instant proceedings were initiated on a mistaken advice, the period of pendency of the instant writ petitions be excluded while computing the period of limitation for filing the appeal. Mr. B. Sharma submits, learned counsel for the petition, respondent submits, that the impugned orders, the orders impugned in the instant, the orders under section 5 of the Act of 1971 impugned in the instant proceedings were passed as far back as on 24/11/2017. The petitioner, though, has the liberty to file an appeal under section 9, but that would be subject to the limitation as prescribed under section 9(2) of the said Act of 1971. He, however, does not object as regards excluding the period of limitation during the pendency of the instant proceedings. Taking into account the same, this court therefore permits the petitioners to withdraw the instant writ petitions with the liberty to file, to approach the appropriate forum in terms with Rule 9, Section 9 of the Act of 1971. In doing so, well, further to that, this court observes that a period
24/11/17.
No, not to. The period from all these writ petitions were filed on the same day.
Same day.
Same day. The period from 2nd of September 2021 till date, till the date of passing of the instant order be excluded while computing the period of limitation. The above, all the three writ petitions stands disposed.
Much.
Yes, Mr. Mohanto?
3 and 4.
Yes, tell me.
Only
But-
my lord, that secret ballot was not done, that is why I am for your lord.
Then?
18.5. The violation of 18.5.
What is the secret ballot business? How do you make it a secret ballot?
The casting of vote should not be, my lord, identifiable. If it is identifiable, it is not a vote casting of, it is not a secret ballot.
Is it your allegation that in the secret ballot, the names were mentioned
Yes, signature and seal is there
of?
of the person concerned.
Show it to me.
That is my lord, record will be produced, my lord, record is not with me, my lord.
Why should I call for that? You have to show me something.
That I made a statement, they have not denied it. Your lordship kindly see what I have stated in para 10, my lord. Para 13, my lord.
Yeah?
Para 13, my lord.
Yes, where?
My
No
petition,
confidence against the petitioner was adopted by open ballot, not by secret ballot as mandated under so and so. In the meeting, entire voting process was undertaken in violation of AR where secrecy of ballot was not maintained. There, all the members were called to the table of so and so one by one, where so and so were provided a seat. In the said seat, written in Golai, so and so, one do not want confidence demand. The members were asked to put tick mark either on the option one lage nalage in the sheet and to put his her seal and signature. In such process, the secrecy of the ballot were not maintained and the process of voting cannot be said to be secrecy under so and so. Now, what is their reply in paragraph number
10, my lord, 10.
10, my lord.
10.
We have given a reply, na? Page?
Page 5.
No.
Page 5, paragraph.
Affidavit in opposition filed by my lord, respondent number 9.
This affidavit filed by all the members who have cast the vote against the president.
Where para 10
Para 10, my lord.
were fully complied with, the members were called one by one and provided with a ballot paper and they were asked to vote one by one and to submit the ballot here. When all the members have voted, their folded ballot were opened and counted. Thus, the secrecy was fully maintained and there was no violation. Then,
And my lord,
That's all.
and my lord, to that effect, no reply was filed, my lord.
which one?
Against this affidavit in opposition, no reply was filed.
Nothing. You have
My
enjoyed?
lord, your lordship kindly is not denied my statement. Your
Yeah.
lordship kindly see, I say specifically said that they put their signature and seal. But they have not denied it, my lord.
No, they said.
They simply said,
They have said in that they have put it. They didn't say anything about seal and signature.
that's why, my lord, they have not denied my statement made by the petitioner, not
Let
denied
us see
by
the Panchayat Act. Hey,
Yes.
Panchayat Act, conduct.
18.5, my lord.
Are you still being the president?
Yes, my
Yes,
lord.
ma'am. There is a status quo
There's a
order.
stay order, my lord.
A status quo order, ma'am.
And probably there are 4 or 5 months left, my lord. My tenure will be.
Oh, but then also the law is law. We have to take it. That's how I call it. Panchayat Act.
No, if it is a secrecy, my lord, it is a secret ballot, then my lord, that there's no meaning at all, my lord, secrecy.
But where is the meaning? Where the secret happens? Means how the secrecy has to be maintained. Ekon no, nila ako na secret. Let us see section 18.5. The voting in any meeting of Gaon Panchayat, if required, shall be by raising of hands, except in a meeting where no conflict is discussed, where the matter will be decided by secret
Secret
ballot.
ballot.
So what is this secret ballot?
Secret ballot, my lord, as per the election commission guidelines, my lord, that it is not been identifiable and normally procedure is that, my lord, that ballot box has to be used. But without ballot box, they fold it.
But how can you equate the election commission thing out here?
But then what is the meaning? Secret means, my lord, if my lord, my vote is identifiable, it is not a secret.
No. If your vote is not, you should have your own right without letting others know what you are voting.
What my voting, my lord, if my signature and seal is there, it is open to all, my lord. Then.
How has the petitioner been able to know this? How is the petitioner?
That is my statement. They have not
Is
been
there any
denied till
substance-
today.
Is
They are
there
the-
anything to substantiate this, my lord?
They have not been denied till today. They have not filed an affidavit also. my lord.
My lord, the members themselves have filed the affidavit, my lord, who have cast the vote. Why
My
are
lord,
we
let
required
it-
to
I
cast-
have made a statement
File an
that there is a videography, my lord. Let them produce the videograph, my lord.
No business.
No, my lord, your lordship kindly see them. There is no meaning of secrecy, my lord. That's why, my lord, in other meeting, my lord, you can raise your hand, you can elect anyone.
Hey, Nila kita kona. Nai niya matat. Luan video. Call the librarian. They told them.
And then your lordship kindly, my lord, if your lordship regarding that secret, what is the meaning of secret, man? I'll go on that point. Some other day.
No.
No, my lord, because
This court does not adjourn any.
my lord, that's my submission before your lordship. The here secrecy is not.
You can
maintained.
very well further argue out there in any other place, but this court does not grant any adjournments on this top of the list. Is discussed where the matter will be decided by secret ballot. How many members are there?
Total 10,
10 members.
10. 7 voted in favor of no confidence.
Total members, how many are there?
10. So 1/3 will be 7. Madam.
Are you still strongly against the petitioner?
Madam, 2021, Madam, hope so much. 2021, this resolution was passed, Madam. Hope so much.
The fact that the petitions, their reply still exists as it is. It hasn't changed.
Has not changed, but that was in 2021. No?
Yes, that's true.
But now what has happened? Hmm?
Which direction?
You have the ballot paper?
No, man.
With whom the ballot paper is?
It will be the deputy commissioner. It will be with the deputy commissioner.
There is a specific allegation out here that the voting, there was a mention of sign and seal. Seal, I don't understand where is the question of seal right? But the sign is there. What seal did you put? You were also voting, I suppose?
No, man.
Why? You have no right to vote.
I'm a president. I'm just thinking, no.
Huh?
They're voting against me, man.
No, you have, can't you
No,
vote?
Town Panchayat
Only the
election is
members who
something
vote.
different. I'm not a member.
It's only the members who vote.
I'm not a member.
Hmm.
I'm directly elected. It is the case, my lord. Here in my lord, very just like American president election, my lord. The president is my lord elected by
So
the.
you have no right to vote.
Yes,
How do you know this aspect have happened?
my lord.
That there was a signature and seal put out there? Were you present?
Yes, I was present. That was called by me. Meeting was called by me because it is my duty to call the meeting. I call the meeting, my lord. And one is voting in my favor also.
Hmm.
So I get it.
So you were
I have
present.
seen, my lord. I have seen, my lord. Because it was only open, my lord. Let's hold that in, give it to the my lord president.
So the
President
vice president was the
president presided over the meeting, my lord.
presiding over the
Yeah.
meeting. And what were you doing there?
But I call for, I have to be there, my lord.
Huh?
I have to be there because that meeting was called by
Okay,
me.
very
My
well.
duty.
Now, what were you doing there?
My lord.
No, I'm asking you because then this court has to know this because
My lord.
you are saying this from your knowledge.
Ah, yes.
So that is what I'm asking you. Why? I mean, what were you doing there?
I don't know, my lord, why yes.
Then how do you know that this was sealed
My
and
lord,
signed?
one of the, my lord, from my knowledge, my lord, because one of the, my lord, one of the member is voting in my favor, my lord.
So that member told you?
That I have not disclosed, my
No,
lord.
then how do you know
No,
this?
my lord, I am, your lordship kindly see.
No.
Definitely, my lord, there is
Mr. Mohanta, you have to understand as to why you are saying this means there has to be some basis.
Exactly.
If the basis has to be either you saw it with you or you have heard it from somebody.
my lord.
You must have stated that from somebody, you must have gained the knowledge. Where?
And all the members who cast their vote against the petitioner are here. He is representing them.
From where do you say that?
From my knowledge, I have that, during that para, I have from my knowledge.
So where is your knowledge? Were you present? That is why I'm asking you. Were you present in a meeting? How could you say to from your knowledge? This is done by the lawyer. Then on what basis are you saying that? This petition is not on an affidavit.
Yes.
No affidavit. It's on verification. See of the lawyer.
Yes, correct.
Then
Mean,
And they have replied by way of an affidavit.
No, let me just verify because I have not seen that, my lord, whether affidavit is there or not, my lord. But they have not, although they filed affidavit, they have not denied, my lord. They said, my lord,
What is there to deny?
regarding seals.
They
my
have
lord,
categorically said that the secret ballot was duly maintained.
that how it is maintained, that is not been, my lord, done.
How it is maintained means you were not present.
I was present there, my lord.
No, therefore, you have to somehow something has to be mentioned once this reply was filed. When was the reply filed? The reply was filed as far back as on 7/8/2021.
There is no chance of filing reply, my lord, because it was hard and it was reserved, my lord.
If they wanted to, my lord, they.
Then if your lordship now again, my lord, again I forget this matter, my lord. Yeah, now again it is came up, my lord, that's why I'm before, if your lordship allow me, I'll file a reply.
Mr. Counsel, wait. This affidavit was filed on 7/8/2021. The matter came up before Justice P.K. Dekha on 7/9/2021. Then the matter came up before Justice P.K. Dekha on 13/9/2021. Then the matter came up before Justice M.R. Pathak on 30/9/2021. Then it came up before Justice P.K. Dekha on 5/10/2021. Then you say that you don't have the opportunity?
No, they file a miscase, my lord.
No, I'm not on miscase. I'm saying on the affidavit.
They are miscase, my lord.
The affidavit on 7/8/2021, where have you mentioned? Why you are saying that you didn't get a chance to reply?
No, I am submitting that, my lord, your lordship kindly see. They have not
Mr.
denied.
Mohanta, this is not what
If
is
your
there.
lordship on
appearance.
that ground, your lordship, my lord, I have nothing to say, my lord. But your lordship kindly see the secrecy has not maintained, my lord, as per rule, my lord. They have not done it. They have not denied it, my lord. They say, my lord, maintain so and so. Is it enough, my lord? When I put a.
But Mr. Mohanta, are you going to say that the strict laws of CPC apply in repetition?
Secret, my lord.
No, strict laws of CPC applies in repetition. The laws of pleadings applies in a repetition. Then why are you stating these facts? These aspects of the matter, these are the evidence. Then you can't do under order 6 rule 2. Then how are you doing it? Therefore, the Supreme Court in 1987 categorically says that what is the difference between a CPC pleading as well as a
What I am
repetition
submitting,
pleading?
my lord, the query which I have made, they have not specifically denied. Since it is effectively denied.
They say that it is strictly secret. They have given it in a particular manner. You should have replied to that.
The one member who voted in my favor, in fact, he filed a affidavit also.
Where?
No, he's not, he sent a affidavit, but it was
That
not.
affidavit you have not brought on
not
record.
on record. No, my lord, your lordship kindly see, my lord, as a petitioner, it is not, my lord, I cannot know everything, my lord, but when, my lord, I.
No, understood. But on 7/8/2021, you knew about it. That they have made this allegation that no, you should have brought in that aspect, something.
Yes, that affidavit is there, he must there.
But these aspects needs to have been brought in.
Give me a chance, my lord, I'll give it.
Huh?
Give me 2 days time.
Why?
I'll file it.
Why should I give you time? This was long time back. It was there. And there was 7-8 dates which has happened. The CAB must have been done only sometime around
February 2022.
huh?
February 2022.
7.
February 2022.
So this was on 10/12/2022. It came up before Justice Manish Chaudhary. 12/11/2021. It came up before Justice Manish Chaudhary.
2nd of February.
Then 26/10/2021. It came up before.
And my lord,
Yeah,
your lordship
Justice
kindly
Soumitra
see, my
Sekhya.
lord. Yes, I have not denied it, my lord. I have not filed affidavit.
Yeah.
Very much, my lord, that they can produce the record matter will me and my lord. Your lordship kindly see by the government official at the respondent not will come before this honorable court, my lord. Not a file affidavit, my lord, not a record was also not produced, my lord. My lord, your lordship kindly see, when as a petitioner I made an allegation, my lord, that secrecy was not maintained by putting signature. So, my lord, if it is allowed, my lord, then there will be, my lord, no secret ballot, no meaning of secret ballot, my lord. So that's why I'm submitting, my lord, that's not actually, that is why it is different. No motion is different than other meeting, my lord.
But there is no interim order after 7/10/2021.
That is not continued, my lord, but since that order is there, my lord.
No, it was, in the first order, it was mentioned
12/7
that till, first order, it was mentioned
Yes.
12/7 till next date.
status.
Status quo as on today shall be maintained in respect to the post of president. Thereafter, there was no extension, nothing, except on 5/10/2021, interim order is extended till next date. Thereafter, matter came up on 7/10/2021. There is no interim order. Thereafter, the matter has come up on various occasions. There is no interim order. Mr. Monto, why is this secret ballot kept for no confidence motion?
Because, my lord, just to maintain the secrecy, that, my lord, any voter, my lord, any voter can, my lord, cast their vote without fear and favor.
Fear.
That is the reason.
So whose right is being infringed if it is not secret?
Definitely decision is going to be, my lord.
No, I'm not on due. Whose right is actually getting infringed?
To those persons concerned, my lord, to vote.
Are they before this court?
Yes, they are all party, my lord.
No, are they before this court challenging it that there shouldn't have been secret meeting?
No, they are not before. Then, my lord, if it is so, then, my lord, there will be no challenge, my lord, any no confidence motion, my lord. Because it is ultimate result to, my lord, against me.
So there may not be, somebody may not like it. A person very well, just for example, you were a voter out there, you can very well say that this particular meeting was held, there was no secret meeting, and as such, it's bad because I have a right under here to cast my vote as a secret ballot.
So that, my lord, no more voter will come. In no combination, no voter will come, because their target is me, my lord. They will take a decision. My submission before your lordship, my lord, since they take a decision from against me, they have to follow the rules, my lord. They have to follow the law. Who will before your lordship, who will come by, that is not a matter, my lord. Matter is, my lord, whether while removing me from the share, whether the rules was followed or not. That is the case. Secrecy is whether, my lord, they have made it. Because, so yes, if it is, my lord, identifiable, my lord, if somebody in some PCR they have done it, if you put against so and so, then I'll keep. That is why, my lord, in Apex Code also says, my lord, is without fear and favor, my lord. That is why it is, my lord. What is the meaning of secrecy? Secrecy meaning is that, my lord. Nobody should be know that, my lord. Nobody should influence me, my lord. Because whatever thing in my mind, and I have to cast.
Nobody should influence the voter.
Voters.
This is it. But the voter is not
But
before this
in,
court.
in case of no confidence, no voter will come.
No,
to the
they-
vote, my lord.
nobody comes, it is
My
a
lord,
different
that
thing,
let
but the
us
right
separate
has
area,
been
my
given
lord.
to
For
you.
academic discussion, we will make it, my lord. But
Huh?
my lord, my submission before your lordship, that since my lord, I am the target, so without following me, I should not be removed. So that is my.
But there is no, they have categorically stated on affidavit that there was a secret ballot.
But they have not denied my.
But you have not denied it.
No, they have not denied my the signature.
That is not an affidavit. That is only on the purpose of during the COVID times, we were only allowed to do it by verification for urgency. You should have thereafter filed your reply to that. You have not done that. Then how does this court take into account this? I would have understood that if it was on affidavit, I could have very well set aside that thing and asked them to go ahead if they desired to. But that is not there.
Give me 2 days time, my lord, I'll file it. Because it is, yes, it is there, my lord. It is
No.
affidavit by one of the, my lord, person who voted against, who is not voted, my lord, he is, if I explain a affidavit. So give me 2 days time, I'll file it. Because, secrecy. no-
I will make it very clear that there is no interim order. Make it very clear. There is no interim order which exists after this. Thereafter, you take whatever decision.
Of course, I file an application for.
My lord, that's
extend
one of
that.
the,
My lord, one thing I point out, my lord, while submitting the requisition letter, my lord, 8 members have signed the requisition letter.
he was well aware, and he knew actually who exactly were actually the person who actually could be
Going
casting
to
the
vote
vote.
against him. So 8 members have signed, my lord.
In
Out
fact,
of 8, 7.
the right to secret vote has been given to the voters so that they may not be targeted later on by you
Or
Exactly.
anybody
Or
else.
by others, anybody.
or by the other.
Anyway,
That is the
purpose,
reason.
that is the purpose. So
So
instead
the
of-
right is to them,
Exactly, my lord, but target is me.
maybe, but because you have been targeted and the right was there to that particular person out of fear that you may target, can you approach this court?
No.
No, my lord, then my lord, whole system will be frustrated. my
No,
lord.
it is
my
not, but
lord,
the right has been given to them.
No, but they never come, my lord.
Now, tomorrow in the election commission,
My lord, suppose.
I am saying in an election matter, let us assume a person has not been allowed to vote. I mean, say that nothing is there. You are going to say everything or details have been given. You have to mention everything open voting. There is a fear that that person may be later on affected. The fear and favor is of the voter, not the person, the candidate. The candidate may target.
Yes,
Then
Moreover, the members who have actually casted a vote against the petitioners.
nothing, Mr.
Represent
Angie.
them,
I am
and they have
dismissing it.
never ever actually made any.
Heard, Mr. You have enjoyed a lot.
give me 2 days time, I'll file it.
Huh?
Give me 2 days time, I'll.
No. Enough. Mr. Mohanta, you have already enjoyed a lot.
My lord, being in minority.
No, my lord, at least, my lord, not,
We actually
not
have no
in this
right,
case,
my
my
lord,
lord,
to
at least,
continue
my lord, they should know, my lord,
There
how
has
to,
been
my
more
lord,
than
follow the
two-thirds
law.
majority against him.
Please, my lord, your lordship kindly see, your lordship, that secret, so my lord, your lordship kindly see that it's a capital punishment for the president, my lord.
What?
For the punishment, he's been removed, he's been elected by the, my lord, voters, my lord, not by the public, my lord, and he is removed by 10 of the members, my lord.
How many members are there, therefore?
10,
So 10 members have removed.
no, 7 is only voted, my lord. 3 are not coming, my lord. 1 is, my lord, although they have said that they are 8 signed, my lord, 1 is not voted, my lord.
One has refrained.
So
No, it
my
is written
submission
out
before
there.
your lordship, this is, my lord, while giving a capital punishment against the, my lord, president, you have to follow the law in toto.
This is democracy, man. Not capital punishment.
Okay. Heard a lot. Heard Mr. TJ Mohanta, the learned
Otherwise, my
senior
lord,
counsel.
otherwise, my lord, will be a bad precedent, my lord. They will,
Huh?
tomorrow, my lord, they will piece of paper, yes, they'll submit it. There will be that, no, law, my lord, does not permit it, my lord.
Okay, you want, I won't discuss that aspect of the matter. Keep it open. I can dismiss it on other ground. Heard Mr.
It is
TJ
today's
Mohanta,
time.
the learned senior counsel. Mr. Mohanta, you have enjoyed a lot on the basis of a presumed deemed interim order.
Interim order, my lord, I have filed an application to extend it, my lord, of course.
And there's no interim order today. There's no interim order from 7/10/2021. There's no interim order.
But till today, I am holding.
If you had put by way of an affidavit, I could have very well set aside this
My lord,
and allowed them
that
to do it.
I admit it, my lord, because of.
But that has, Mr. Mohanta,
Give me
you have,
one day
no,
time.
Mr. Mohanta, you have to be fair also to the, if you have done it, this affidavit would have been filed by you, a reply had been filed that anything to that effect, that yes, I reiterate the statements made. I would have very well said that. I would have set aside this and allowed them to go ahead with, in terms with 15. But how can give me a handle? How can I do that?
No, actually, I am sorry, my lord, for that I am paying only one.
Because
day
I
time.
have
No,
already,
I'm not-
I have, Mr. Mohanta, I have already spoken it out to them. Now they will put that submission out there that we have filed a reply. They have, the matter has been there till 2022, they didn't reply. Tell me.
Actually, because of this CAV, my lord, everything forget, my lord.
So you have, but because of the CAV, you have been enjoying on a presumed stay order enough.
Give me one day time.
No, Mr. Mohanta, you be fair. Enough, you have enjoyed. Heard Mr. TJ Mohanta, the learned senior counsel, assisted by Mr. A.K. Gupta appears on behalf of
Respondent number 7, 9 to 13, 16, 17, 18.
Mr. N.K. Devnath appears on behalf of the Panchayat and Rural Development Department. The instant writ petition was filed challenging the special meeting held on 21/6/2021 in pursuance to the letter number GGP/OL/2000/21-22 dated 19/6/2021 issued by the Secretary Golai Gaon Panchayat, as well as the resolution dated 21/6/2021 passed in the special meeting dated 21/6/2021 expressing no confidence against the petitioner as President number 1 Golai Gaon Panchayat Digboi, Tinsukia. A perusal of the materials on record show that the grievance of the petitioner, who was the president, was that the mandate as required under section 18(5) of the Assam Panchayat Act 1994 of holding a no confidence motion through secret ballot was not maintained. The instant writ petition was filed at the time when this court in the administrative side permitted filing of the writ petition without an affidavit on the basis of a certificate and or verification issued made by the council on the basis of a certificate being made by the council. Pursuant to the notice so issued by this court on 12/7/2021, an affidavit in opposition was filed by the respondent numbers 9, 10, 11, 12, 13, 16, 17, and 18. Wherein at paragraph number 10, it was categorically mentioned that the members were called one by one and provided with a ballot paper. And they were asked to vote one by one and to submit the ballot sheet in folded condition. It is only after all the members have voted, then the folded ballot sheets were opened and counted. And as such, the secrecy of the ballot were fully maintained, and there was no violation of section 18(5) of the Assam Panchayat Act 1994. The said affidavit was filed on 7th of August 2021. And thereupon, the matter was listed on 7/9/2021, 13/9/2021, 30/9/2021, 5/10/2021, 7/10/2021, 26/10/2021, 12/11/2021, and 10/12/2021. It is also relevant to take note of that an interlocutory application was filed being IA civil number 1236/2021, seeking modification and or vacation of the order dated 12/7/2021 passed by this court in the accompanying writ petition in the present writ proceedings. The said application was also filed on 7/8/2021. When the said interlocutory application was taken up on 28/2021, this court, taking into account that the issue and the nature of argument placed would lead to a final disposal, if taken into consideration, would ultimately lead to the decision of the matter on merits, directed the said writ petition to be listed on 7/9/2021 for final disposal. In the said application, interlocutory application at paragraph number 7, in the same vein as has been stated in paragraph number 10 of the affidavit in opposition, it was mentioned that all the members have voted mentioned that all the members were called one by one and provided with the balance sheet, and they were asked to vote one by one and to submit the ballot sheet in folded condition. It was further mentioned that when the members had voted, then the folded ballot sheets were opened and counted. And as such, the secrecy of the ballot were fully maintained, and there was no violation to section 18(5) of the Assam Panchayat Act 1994. There was no reply to the said application even, and more particularly to paragraph number 7 of the interlocutory application. Although the records, if seen, would clearly show that the petitioner duly had the opportunity to rebut to such allegations made in the interlocutory application, as well as also file a reply rebutting the allegations, statements made in paragraph number 10 of the affidavit in opposition, more so when the writ petition so filed was not based upon, was not verified by way of an affidavit. Next. It is further relevant to take note of in the above backdrop. Let this court therefore take into consideration the submission made by the learned counsel for the petitioner, the learned counsel for the parties. Mr. T.J. Mohanto, the learned senior counsel, submitted that section 18(5) of the Assam Panchayat Act 1994 categorically mandates that in the case of a no confidence motion, the voting shall be by way of secret ballot. The learned senior counsel therefore submitted that the legislature have intentionally put the secret ballot for no confidence motion. But however, in respect to other resolutions, the same could be done by show of hands. Therefore, the resolutions so adopted, which have been impugned in the instant proceedings, having been adopted without a secret ballot, not by way of secret ballot, as in the ballot papers, there was the requirement of putting the sign and seal. Therefore, the entire resolution so adopted and the meeting held and the resolution so stands vitiated. Anything else?
That's all.
But still I am paying.
Should I put the capital punishment also submission?
Already, my lord.
No, should I put there?
No, for president, my lord, removing is a capital punishment, my lord.
If it is submitted. That the president of a Gram Panchayat is an office elected by the people. And under such circumstances, the strict mandate of the law has to be enforced. Capital punishment not necessary. That is it.
It's a democratic right.
On the other hand, Mr. A.K. Gupta, on the other hand, Mr. N.K. Devnath, the learned counsel appearing on behalf of the Panchayat and Rural Development Department, submits that from the pleadings, so from the affidavits, as well as the interlocutory applications so filed by the members who were present, there is a categorical statement to the effect that the voting was done in ballot papers with which was submitted in folded condition, and it was opened upon completion of the voting. The members therein on affidavit have categorically mentioned that the mandate of section 18(5) of having a secret ballot was duly maintained. He further submitted that in the instant case, in respect to the instant Gram Panchayat, there are 10 members, of which 8 members submitted the requisition in terms with section 15 of the Act of 1994. And in the voting and from the resolution, it would be seen that 7 members voted against, for the no confidence motion against the petitioner. 1 member voted against the no confidence motion, and the other, and another member refrained from voting. The Learned Counsel therefore submitted that in the spirit of democracy, which is the touchstone in respect to a Gram Panchayat, the petitioner has no right to further continue as the president of the said Gram Panchayat. Anything else? Mr. A.K. Gupta, the Learned Counsel appearing on behalf of the private respondents, further submitted that the members who were present in the meeting have filed their affidavit and have specifically stated that the secret ballot was maintained. This aspect have not been denied by the petitioner, nor any material have been produced which would show otherwise. The learned counsel therefore submitted that as the petitioner was not a member, he neither, and the question of no confidence of the president was in question, was in issue. The petitioner, it is only the vice president who could have presided over the meeting. And as the petitioner was not a member, the ballot paper was not given to him. Under such circumstances, the question of the petitioner making these allegations in paragraph number 16 of the writ petition does not arise. Anything else?
Well, actually, record was produced before this honorable court, according to their custody matter. Still, my lord.
There, the record is there. That is the Fed book, no? So that record is there.
My lord, very much. My lord, they can verify it.
No, you've got the record?
I do not have any record. My lord, the report.
Enough is records. Record.
No,
I've heard the learned counsels for the parties.
on 5/10/2021, they have submitted a submission that record is there and I will be getting that.
Mr. Counsel, record is necessary when the court feels the necessity.
No, but still, my lord, sign and signature is not been rebutted, my lord, not been verified from the record of the bill. Regarding, my lord,
You made a what?
I made a statement that, my lord.
Statement on what?
Whatever at that point of time, my lord.
On what?
knowledge,
Understood, but then thereafter,
But it has to be verified, since nobody rebutted it, my lord, it has to be verified in the record, my lord. It is very much before the court, my lord. That is all.
I've heard the learned counsel for the parties. Take it up in appeal. I've heard the learned counsel for the parties. And peruse the materials before this court. The materials on record clearly show that the petitioner herein had filed a writ petition alleging the violation of section 18(5) in paragraph number 14, 13. It has been mentioned that the secrecy of the ballots were not maintained. In as much as in the ballot papers, the members were asked to put their seal and signature. As already stated here in above, this court, the High Court, the High Court, no, this court on the administrative side had permitted filing of writ petitions on the basis of certificate by the council. And as such, the said statement is based upon a certificate given by the council. This was done so on account of the COVID pandemic and to avoid what? What was that? I forgot the name. They used to, no? One word is used. There is something to avoid. What was that? What was the reason? Avoid. Avoid. Be it as it may, the petitioner being the president, and as it is the and as the resolution as well and as the meeting was called for a decision or decision the call for deciding the no confidence of the president, it is the vice president who has to preside over the meeting. In paragraph number 11 of the said writ petition, the petitioner have categorically mentioned that he was not present in the meeting. First. Under such circumstances, first of all, in the backdrop of the above, the respondents in their affidavit have categorically mentioned that the members were called one by one and provided with a ballot paper, and they were asked to vote one by one and to submit the ballot sheet in folded condition. It was further mentioned that when all the members have voted, then the folded ballot sheet were opened and counted. And as such, the secrecy of the ballot was fully maintained and there was no violation to section 18(5) of the Assam Panchayat Act 1994. It is even seen that the petitioner, having had the opportunity, did not rebut to the statements made in paragraph number 10 of the affidavit in opposition filed by the private respondents, as well as paragraph number 7, which is also in the same vein of the interlocutory application. First, under such circumstances, this court has no other option is of the considered opinion that as the petitioner then himself states in his petition that he was not present in the meeting. Yes.
Actually, my lord, probably in my petition, I am not present, is present, my lord, I have misstated, my lord, that is really the correction made.
No, in paragraph 12 it is mentioned, not present.
My lord, paragraph 12, your lordship.
Well, page 12.
Page 12, my lord. I'll correct it, my lord. Your lordship kindly see that not orders, my lord, remove, probably it was not corrected.
The petitioner was, however, not present in the meeting.
But that not was, my lord, probably it was not.
No,
I'm
sorry, Mr.
No, your lordship kindly see the resolution. In resolution, it is reflected that I was present.
You maybe not then at that point of time.
Your lordship kindly see the resolution very much reflected that, my lord, I was present. If I go by the resolution, my lord, annexure 7, my lord. Thereafter, the President Gram Panchayat Srimati Janmani Pasha expressed her views on the allegation brought to her at page 45 to page 46. 44.
Page
44.
Yes. 40?
44.
Yes.
Last page. Thereafter, the President of Gram Panchayat Srimati Janmani Kasari expressed her view on the allegation brought to the ward members against her. Firstly, she stated that each and every scheme under the 14-15 commission was taken up after discussion with the ward member disposed rising such situation like no confidence. She has placed detailed particulars to each scheme in front of President. President means that President who presided over them. Before voting, my lord, there is a discussion, my lord. She took part in the discussion.
This must have been before voting.
Yes, my lord. That is a procedure, my lord. Before voting, my lord, she has to defend, my lord. Any president who is against whom, my lord, my lord, he has to defend his case.
No, that has been given, but that is different from at the time of voting. You may not be paid. You have stated out here. You have not denied to that.
Same meeting, same hall, my lord.
Next. Enough. Considered opinion that the petitioner have not been able to make out a case for violation of section 18(5) of the Act. First, next. Mr. T.J. Mohanto, the learned senior counsel, further submitted that although in paragraph number 10 of the writ petition, it was mentioned that the petitioner was not, now further tried to explain that although in paragraph number 10 of the writ petition, it has been mentioned that the petitioner was not present in the meeting. But actually the petitioner was present. In the said meeting, as would be apparent from the resolution so adopted on 21/6/2021, wherein there is a mention that the petitioner had expressed his views, her views, and had also explained on the other hand, Mr. Who wants to counter that? Any of you? Whose name do I put? You, Mr. N.K. Debnath. On the other hand, Mr. N.K. Debnath, the learned counsel appearing on behalf of the Panchayat and Rural Development Department, submits that when a meeting is called for no confidence, the petitioner is given an opportunity, the president is given an opportunity to explain. And as such, and the same was duly done, as is recorded in the minutes of the meeting dated 21/6/2021. But at the voting, the petition, the president is not present, is never present. As the president cannot vote. The said submission of Mr. N.K. Devnath duly explains as to why the petitioner had mentioned at paragraph number 10 that he was not present in the meeting. Accordingly, this court dismisses the instance.
I admit it, not present is my clerical mistake, because in my petition is corrected, but it forget to my.
No, in the main petition we'll go by.
And that's why it is clerical mistake. That's why I'm submitting from the record, my.
No, you can't, I've explained the record. Pending applications if any.
My lord, item number 4, I mean, I'm not pressing it.
Item number 4 is what?
My lord, I have filed a fresh writ petition since no order was passed. That since 6 months have passed, I have approached the authority for submitting a fresh writ petition. They are not accepting that.
Oh, this one.
Yes, ma'am. I'm not.
6 months have gone by.
Yes,
You're not pressing.
not pressing it.
Heard Mr. A.K. Gupta, the learned counsel for the petitioner. You are appearing, Mr. Monto?
In this case, no. It's not a party matter.
I'm not a party.
Mr. N.K. Devnath appears on behalf of the PNRD department. The learned counsel for the petitioner submits that in view of the order so passed in
WPC number 3240 of 2021.
2021, he does not want to press WPC number 4173 of the instant writ petition. Accordingly, the instant writ petition stands closed.
Obliged.
Yes, Mr. Roy.
My lord, here the petitioner's technical bid was rejected.
Why?
Because he did not submit the required certificate. They were saying that's why. The others submitted the certificate. L1 bidder was given the work long back, my lord, and the contract, I think it will be for a few months left because for 2 years contract, my lord.
There was no stay.
There was no stay.
What certificate he didn't give?
That MSME, he said is covered as an MSME certificate, no, for getting the benefit exemption of EMD, my lord. My lord will.
Show me which one. As
My
per
lord
the
will-
tender, what certificate is required?
My lord will see the, take up my affidavit. I've given the technical committee report.
The tender condition, which is the certificate which is
Oh,
required?
my lord, it is at close, page 28, my lord will find. Twenty-seven, my lord.
Yeah.
Clause 4, terms of micro, small enterprises.
Tender document will not be charged. Document cost will not be charged from micro. MSME registered with agency for exempt tender will be exempted from payment. Who are interested in prevailing petition of these benefits, prepare written note with their offer, proof of their registered or goods produced. Yes, what
And
is the
next page, my lord, also, clause 5 and 6.
The benefit is stated above to MSME shall be available for goods, services produced and provided by MSME for which they are registered. Does not fulfill the criteria serious to such offer will be considered for benefit. Then,
my lord will kindly see the technical bid committee report. My lord, you will also take up my affidavit. My lord.
yes, where?
My lord will find that page page 12, my lord, lecture D.
Page 12.
Lordship.
We are concerned with
The real petitioner is
SK Enterprise.
SK Enterprise.
where is it? SK Enterprise. Sorry. Technically disqualified non-payment of the EMDS certificate submitted is not related to the instant tender item. Tender may be rejected under clause. So they did not submit the EMD.
They did not submit it.
And they did not have a certificate which gives the benefit in terms of.
Lord, that's it.
Heard none appears on behalf of the petitioner on call. Mr. P.K. Roy, the learned senior counsel, assisted by
SK Chakravarti.
appears on behalf of the FCI. The
All
respondent
the
numbers 1,
respondents.
2, and 3. The instant writ petition has been filed challenging the rejection of the bid of the petitioner. Against tender number SNC/2171/Assam/AP/2021. To the said writ petition, the tender document, the model tender form have been enclosed. Where's the EMD?
My lord, EMD Lordship will find.
Clause 6 of the said general information to tender stipulates that each tender must be accompanied by an earnest money at the rate of 2% of the contract, which must be submitted electronically through NEFT/RTGS/other electronic means by the tenderers, for which concerned FCI/RO will provide its bank account number and concerned branch of the bank where the account is to be held. It was further mentioned in clause number 6, stipulated in clause number 6, that in case of NEFT/RTGS/other electronic means, the tenderer has to indicate the transaction number (UTR number) close, of such payment appropriately in the bid. It is further seen that in terms with clause 14, certain exemptions have been granted to the micro and small enterprises. In terms with clause 14, Roman 2, capital, the micro and small enterprises (MSE) registered with agencies for the items tendered will be exempted from payment of earnest money deposit. In clause Roman 3, in subclause Roman 3 of clause 14, it has been further mentioned that the MSCs who are interested in availing themselves of these benefits and preferential treatment will enclose with their offer the proof of their being registered for goods produced and services rendered with any of the agencies mentioned in the notification of the Ministry of MSME, indicated therein with the bid. The agencies have been mentioned to be the District Industry Center, comma, Khadi and Village Industries Commission, comma, Khadi and Village Industries Board, comma, Coir Board, comma, and no, comma, National Small Industries Corporation, comma, Directorate of Handicraft and Handloom, and any other body specified by the Ministry of MSME. In subclause 4 of clause 14, the MSMEs must also indicate the date of their MSc registration, which should be valid as on the last date of submission of the tender. The MSCs further, in order to get exemption and benefits, should upload an attested / self-certified copy of the valid registration certificate, giving details such as stores, / services, etc., failing which they run the risk of their bid being passed over as ineligible for the benefits applicable to the MSCs. In subclause 5 of clause 14, the benefit as stated to MSCs shall be available for goods / services produced and provided by the MSMEs for which they are registered. It appears from the record that the technical bid evaluation committee consisting of the AGM CONT, bracket AGM F/A and AGM MOVT, bracket close, examine the tenders for appointment of the RTC, X, FCI, siding, TEG, bracket, Salvo to FST, THU. Amongst the 9 tenderers, three tenderers, including the petitioner,
Four,
three
madam.
tenders, huh?
Four.
Who have four? Number 1 is qualified.
5 qualified, madam, technically qualified.
No, one is, if you see that, 1 is qualified,
1 is qualified,
2 is disqualified,
2 is disqualified,
3 is disqualified,
3 is disqualified,
4 is qualified,
4 is qualified,
5 is qualified,
5 is qualified,
6 is disqualified,
6 disqualified,
7 is qualified,
7 is qualified,
8 is disqualified,
8 is disqualified,
9 is qualified.
9 is
So
qualified.
1, 2, 3, 4. 4. Amongst the 9 tenderers, 4 tenders were rejected as being technically disqualified, including the petitioner. It appears that It appears from the technical bid evaluation committee report enclosed as Annex D to the affidavit in opposition filed by the respondents that the petitioner did not submit the EMD, but claimed exemption from furnishing the EMD Full. However, the petitioner submitted an MSME bracket Udyam registration certificate pertaining to Division 77, that is rental and leasing activities, which is not relatable to the subject tender of road transport contract. It is under such circumstances, the technical evaluation committee rejected the bid of the petitioner under clause 14 Roman 2, read with clause Roman 14.5 and clause 14.6 of the MTF, means model tender form. Mr. P.K. Roy, the learned senior counsel, further submitted that the said tender was for a period from
the 2 years, from the date of acceptance. I have annexed the
for a period of 2 years. Which was the tender?
My lord.
For a period of 2 years.
2 years, my lord, which will from 2012-2021 to 1912-2023.
From 2012-2021 and to
1912-2023.
2023. The L1 bidder was L1 qualified bidder have already been allotted the contract, and another 6-7 months is only left. Mr. P.K. Roy, the learned counsel, senior counsel, further submitted as the respondent authorities have duly taken action in terms with the tender, model tender form, conditions of the model tender form, and as the petitioner hearing failed to submit the required certificate for claiming exemption as a MSc, it was imperative for the petitioner therefore to submit the EMD. Upon hearing the learned counsel for the parties, for the respondents, and taking note that it is no longer res intriga that a reed court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a tenderer unless something is gross or palpably wrong is pointed out. The court should not interfere in matters relating to tender or contract. To set aside the entire tender process at a stage when the contract is well underway would not be in public interest. This court also cannot be unmindful that initiating a fresh tender process at this stage, that to when only 6 months is left, may consume a lot of time and also loss to the public exchequer. It is under such circumstances, this court is not inclined to interfere with the decision of the court or of the respondents in rejecting the tender of the petitioner. Accordingly, the petition stands dismissed.
Right.
Item 9.
In this case, I need 1 week time to file it.
But no petition.
Already central government has filed lordship.
You know? Yes, tell me.
Well, the petitioner is a research scholar in Department of Physics, my lord, Guwahati University, my lord. She belongs to OBC non-creamy layer, my lord. In this connection, my lord, there is a notification which was issued, my lord, on 8/9/1993, my lord, which your lordship will find at page number 28. 28 of the writ petition, my lord. It starts in page number 28. It's an OM dated 8/9/1993, my lord. Subject is reservation of other backward classes in civil post and services under the government of India. And my lord, it says the undersigned is directed to refer to this department's OM number so and so, dated the 13th August 1990 and 25 September 1991, regarding reservation for socially and educationally backward classes in civil post and services under the government of India. And to say that following the Supreme Court judgment in Indra Sawhney and others versus Union of India, WPC number so and so, the government of India appointed an expert committee to recommend the criteria for exclusion of socially advanced persons / sections from the benefit of reservations for other backward classes in civil post and services under the government of India. I'll not trouble your lordship with the entire OM. I'll just point out the relevant portion. If your lordship kindly turns to the next page, there's a schedule which is appended to this OM. Page number 29 says, my lord, description of category to whom the rule of exclusion will apply. And if your lordship now kindly turns to page number 32, my lord, there's an income and wealth test, my lord. Clause 6, income and wealth test. And it says, sons and daughters of persons having gross annual income of rupees 1 lakh or above, or possessing wealth above the exemption limit as prescribed in the Wealth Tax Act for a period of 3 consecutive years. And if your lordship kindly turns to the next page, it says, my lord, explanation, there's an explanation, my lord. It says, number 1, income from salaries or agricultural land shall not be clubbed. So, my lord, while determining the OBC non-creamy layer, the income from salary and the agricultural land shall not be clubbed, my lord. So this has been provided, my lord. Subsequently, my lord, there has been a clarification reiterating the same thing, my lord. The clarification, your lord,
Salaries or agricultural land shall not be clubbed means club with what?
with the income test, my lord, because 1 lakh is the criteria. If a person exceeds 1 lakh annual income, he will not be considered as OBC non-creamy layer. But if that income is from
Income, where do you get that other income?
annual income, my lord,
Means if you do from business.
yes, my lord. But in
So
my,
a person who is salary,
my lord,
a father who is salary,
my lord,
and he's an OBC,
my lord,
then he would be exempted.
he will be exempted. That is my case.
That is your case.
Because that is what has been said by the Union of India, my lord. If a lordship kindly
1 lakh is extended to 8 lakh rupees. Lordship.
as on that 8 lakh.
1 lakh is extended to Lordship 8 lakh rupees by OM dated 2017 Lordship. They extended.
From time to time that
It's okay. But Mr. Gugoi, kindly tell me,
Lordship,
you can't club
Lordship,
the salaries or agricultural land
Lordship,
income,
Lordship.
meaning thereby?
Lordship, for determination of the Lordship that Lordship income limit 8 lakhs Lordship. There are-
Understood.
Lordship.
That I have
Lordship,
understood. It's
Lordship.
8 lakh. Or let us have it 1 lakh also.
Lordship,
You cannot club
Lordship.
the income from salaries. That means can't you take the salaries, income of the salaries?
Income of the salary you can take Lordship, but we cannot club both income of the salary as well as the agricultural income Lordship. The income.
But why didn't these people use wheat?
Lordship,
They used ore.
Lordship,
The problem arises with that. That is why
Lordship.
Mr. Bulwa was going very fast. It happened for the
Lordship.
court to understand.
Lordship.
What do you mean by the
Lordship,
ore?
wealth test is in respect of Lordship, where there is no any determination regarding equivalence to the public employment and private employment, public sector employment and government employment. Then Lordship, wealth test is applicable Lordship. Otherwise, in the petitioner's case Lordship, petitioner's mother is a class 2 officer in the Assam Education Service, and petitioner's father is a class 3 officer. So Lordship, they are not within the Lordship death category. They are the exemption. They are the exemption category. Lordship. They are entitled for non-criminal certificate Lordship. In respect of both the persons in the class 2 officers Lordship, then they will not entitled for.
We are concerned with which service?
Lordship, they are belongs to the Assam Education Service. The petitioner's mother is a Lordship postgraduate subject teacher, and father is an assistant teacher in the high secondary school. Postgraduate.
No. Petitioner is applying for who?
for OBC non-creamy layer certificate.
Non-criminal certificate.
You are asking for an OBC non-criminal layer certificate.
Lordship.
That has been refused.
That has been given to me.
And
but
recall it
when I-
Lordship.
And when I tried to renew it, my lord, they again issued me, but then again subsequently they reverted it back on the ground that my family income is above 8 lakh. Now that 8
So
lakh
your thing is, you can't take into account salaries.
salaries.
But what can you take then?
Lordship.
If we are going to give that interpretation,
Lordship.
would it mean that the person who is, just for example, my son,
Lordship.
if I am an OBC, as I get my entire thing as salary, so would it be out? Although I come at a high rate.
No, Lordship.
No, ma'am.
No, the exemption part is there. My Lord may kindly place our affidavit. Our affidavit is very clear, Lordship.
Very well.
Affidavit filed by the Lordship. One, Mr. Sandeep Saxena, Lordship. The Ministry of Personal Public Grievance, Lordship. The categories of persons, Lordship, in page 3, Lordship. My Lord may kindly come to Lordship. Paragraph 3, Lordship, permit, I can read it, Lordship. Paragraph.
Please, you are at
Paragraph-
liberty to do.
Lordship, that the deponent begs to state that category 2 service category of the schedule attached in the OM dated so and so provides the criteria for determining creamy layer status of the sons and daughters of persons belonging to OBC category working in central and state government or in organization where the equivalence of post vis-a-vis the post of central and state government has not been established. The relevant provisions of OM dated 8/9/13 are explained as under, Lordship. And also category 2 service category, Lordship. A is Lordship Group A class 1 officers in all India's central and state service direct repeats, Lordship. Sons and daughters of the following are considered as falling under creamy layer, Lordship. Parents both or either of whom are class 1 or Group A officers. Number 2, parents both of whom are class 1 and Group A
Sons and
officers.
daughters of following are considered as falling in criminal.
Creamy layer, Lordship.
irrespective of the salary. basis.
Lordship, irrespective of the salary, lordship. Then lordship 3, parents either of whom is a class 1 officers and such parents dies or suffers permanent incapacitation and before such death or such incapacitation has had the benefits of employment in the international organization like UN, IMF, World Bank, etc. for a period of not less than 5 years, lordship.
So they are excluded.
They are lordship excluded. Then lordship
So they don't get the benefit.
Even lordship, their salary is lower than the 8 lakhs also lordship, but by way of their category lordship, class 1 category, they are not entitled lordship.
NCL.
NCL lordship. Then lordship B, next page B lordship 4. This is in respect of
In
class.
fact, that day I was reading a latest judgment of the Supreme Court. I think as they Justice Ajay Rastogi
Lordship.
and Justice Bella Trivedi, there was the judgment pertained to the question involved was very interesting. That in a OBC NCL,
Lordship. That dissenting judgment, lordship.
Yeah.
Dissenting judgment,
Yeah.
lordship.
OBC NCL,
Lordship.
can a person who is otherwise not qualified at the time
Lordship.
can submit it at the time of scrutiny or anything at a later stage?
The view of the my Lord Justice Bella Trivedi is
Said no,
lordship.
following this Rekha
Lordship.
But the interesting part is
Lordship.
wherein it says that the reservation in so far as what do you call SC, ST,
Lordship.
STP,
Lordship.
aesthetic,
Lordship.
whereas a reservation in terms with OBC, EWS
Lordship.
are all fluid
Lordship.
and dynamic,
Lordship.
and it depends upon the exigencies.
Income generation, other things.
Yes, tell me.
Lordship. Then lordship, page 4 lordship, in respect of Group B class 2 officers of central and state government lordship. A is parents of both whom are class 2 officers. B is parents of whom only the husband is a class 2 officers and gets into class 1 at the age of 40 or earlier lordship. Then C, parents of both of whom are class 2 officers and one of them dies or suffers permanent incapacitation and either of them has had the benefits of employment. Same thing lordship.
So here, group A and Group B.
Group B. Group A
is class 1 and Group B is class 2.
Class 2. Class 2 in respect of both the parents lordship.
Here it is parents.
Parents lordship.
Okay.
Then lordship.
No, but if you see,
lordship.
Okay, incapacitation is suffers from, but one of them dies or suffers incapacitation.
Lordship. And either one of them benefited the lordship employment in the UNO and other things lordship.
Okay.
Then lordship, the next page lordship, employees in public sector undertaking lordship. The criteria enumerated in category 2A and 2B above will apply mutatis mutandi in officers holding equivalent or comparable post in PSU lordship. Bank, insurance organization, universities, etc. And also to equivalent and comparable post and position under the private employment lordship. Pending the evolution of the post on equivalent or comparable basis in these institutions, the criteria specified in category 6, income wealth test lordship. If it is not determined lordship, the wealth test will applicable lordship.
Pending evaluation. Yes.
Then wealth test. Otherwise, wealth test is not applicable on the basis of the lordship, the class lordship. Then lordship, category 6. Category 6 is the in respect of wealth test lordship. Persons having gross annual income rupees 8 lakhs or above, possessing wealth above the exemption limit prescribed wealth test act per period for 3 consecutive years lordship. And persons in category 1 to 3 and 5A who are not disentitled the benefit of reservation but have income from other source of wealth will bring them within the income wealth criteria mentioned in above lordship. An explanation part is lordship. Income from salaries or agricultural land shall not be clubbed. An income criteria in terms of rupees will be modified taking into account the change of value of every 3 years. If the situation, however, so demands, the interest may be less. And then lordship 4.
So income from salaries would not be.
Lordship, only class lordship.
They will only come within the class.
Within the class lordship. Now lordship, Paragraph 5, Lordship. Paragraph 4 is the extension. Paragraph 5, Lordship. That from the above provisions, it may be seen that creamy layer status of the sons and daughters of the central and state government employees are determined on the basis of the criteria as given against the category 2 of the schedule of the OM dated so and so, not on the basis of the income and wealth test, Lordship, as prescribed in the category 6, Lordship. Unless the parents have income from other sources of wealth which will bring them within the income and wealth criteria mentioned in category 6A of the said schedule, Lordship, where there is no any determination of equivalence, Lordship. While calculating income from other sources, income from salaries and agricultural land shall not be clubbed in terms of explanation, so and so, Lordship. Now, paragraph 6 is very important, Lordship, that the deponent begs to state that present case of the petitioner's mother is a class 2 officer being postgraduate teachers, subject teacher, and father is the class 3 officers graduate teacher as per the provisions of Assam Secondary Education Provision Service Rule 2018 as amended 2019. As per Rule 3, Lordship. Rule 3, Lordship, the class and cadre is there, Lordship.
So they don't come under B.
Lordship, they don't come under B.
And as such, he is entitled to.
C is entitled, Lordship. Because,
Yes,
and even paragraph 7, we have specifically stated, Lordship, C is entitled, Lordship.
yes, Mr. Gustami.
Lordship, you have not filed an affidavit, but it is the affidavit filed by the central government in para 7, Lordship. Then categorically mentioned the OBC candidate whose one of the parents is working as Group B and other is working as Group C in the central state government is not considered as falling in the criminal.
So you accept. Why did you want to file affidavit? Heard Mr. A.K. Burwa, the learned counsel, appearing on behalf of the petitioner. Motion. Motion.
Motion, because it remained in motion. Notice was never.
There's a similar order.
There's one case called Junali Nath, my lord.
Huh?
There's one case called Junali Nath.
Junali Nath.
But anyways, perhaps not necessary.
I can deal with it without the. Mr. Who appears for? Oh, your main. Mr. R. Dhar appears for the respondent number 1, 2.
I am for 3, Lordship.
Mr. K. Gogoi appears for the respondent number 3. Mr. N. Goswami appears for the respondent number 4, 5, and 6. The instant repetition is taken up for disposal at the motion stage in view of the fact that the central government, it is the respondent number 3, have already filed an affidavit explaining the office memorandum dated 8th of September 1993. Next. It is the case of the petitioner herein that the petitioner belongs to the other backward classes, bracket non-creamy layer. The petitioners completed her education. The petitioner had passed her Master of Science in the year 2018, and as on the date of filing of the petition, was working as a research scholar in the Department of Physics, Guwahati University. The petitioner's father is an assistant teacher, and her mother is a subject teacher. Assistant teacher where?
In Soraibahi Higher Secondary School, Soraibahi, Morigaon. Paragraph 3, page 5.
No, that is mother.
So both of them in the same school, my lord.
Same school?
Both of them.
Okay. The petitioner's father is an assistant teacher at Soraibahi Higher Secondary School, Soraibahi, Morigaon, Assam. And the petitioner's mother is a graduate subject teacher in the same school. In the year 2019-20, the petitioner applied for the other backward classes, bracket OBC non-creamy layer certificate before the concerned authorities. The authorities concerned issued the OBC oblique non-creamy layer bracket close certificate bearing number 03042-001-019-02027. The same was issued on issued the bearing number on 30/4/2019. 3/4. As the certificate validity of the said certificate was for 1 year, the petitioner again in the year 2020-21 applied for the state level eligibility test under the other backward class non-creamy layer category. The petitioner successfully cleared the examination and the result was published on 5/8/2021. In the meantime, prior to the result being issued, the validity of the certificate dated 3/4/2019 expired. Expired on?
Expired my lord, within 1 week.
2/4/2020. However, on account of pandemic, the COVID pandemic, and the lockdowns as declared by the Revenue and Disaster Management Department, the petitioner could not apply for renewal at that relevant point of time. However, on 2/8/2021, prior to the results being published, the petitioner applied for the renewal of the OBC bracket NCL certificate. Thereupon, on 3/9/2021, the Assistant Commissioner Morigaon issued a certificate to the petitioner certifying that she does not belong to the OBC creamy layer. The said certificate was issued bearing number 03092-001-0371669. However, when the petitioner visited the office of the Deputy Commissioner Morigaon for the purpose of attestation of the said certificate, the petitioner was informed that the said other backward class OBC non-criminal certificate dated 3/9/2021 was reverted back. What is this reverted back word?
Page number 59, my lord. They say official status revert back. Page number 59.
Page number
59. Status reverted back. Revert back. Official reason, family income is 8 lakhs above.
where reverted or reverted
Status.
status
The bottom.
reverted back.
And in the middle, my lord, the reason is given, family income is 8 lakhs above.
Was reverted back. Full stop. The petitioner thereupon on 1/10/2021 checked her application status in the relevant ops website of www.edistrict.assam.gov.in, and the status as regards the petitioner's certificate was shown as reverted back, and the reasons assigned therein is that her family income was above rupees 8 lakhs per annum. Thereupon, the petitioner on 11/10/2021 submitted a representation before the concerned authorities highlighting her grievances. However, there was no positive action taken, for which the petitioner approached this court by filing the present petition. On 2/11/2021. It appears on record that on 15/11/2021, this court issued after recording the entire case of the petitioner, directed the matter to be listed again on 30/11/2021, thereby enabling the respondent number 1 and 2 in the Department of Welfare of Plain Tribes and Backward Classes, the Department of Personnel and Training, Ministry of Personnel, Public Grievance and directed the matter to be listed on 30/11/2021, so that the respondent numbers 1, 2, 3, and 4 could clarify the matter. It further reveals that on 20/12/2021, further reveals from the records that on 20/12/2021, the stand taken by the respondent number 1 and 2, as well as the central government, were duly noted, and thereupon there was a direction upon the central government to file an affidavit in the matter regarding the stand with regard to the OBC certificate creamy layer of the petitioner. The writ petition was thereupon directed to be listed on 1/2/2022. However, on 1/2/2022, there was no consequential matter. Orders passed. Be that as it may, on 25/1/2022, the respondent number 5/3 had duly filed an affidavit in opposition. Thereafter, the matter has been listed today before this court. I've heard the learned counsels appearing on behalf of the parties. The grievance of the petitioner hearing is that the respondent members who is that respondent who have done all these things?
My lord, Deputy Commissioner, Office of the Deputy Commissioner Morigaon, my lord. As revealed.
4
by
and 5.
Page number
No,
59.
4 and 5 has done the problem.
My lord.
4 and 5 lords.
4 and 5, my lord. 4 and 5.
The grievance of the petitioner hearing is that the respondent number 4 and 5, while reverting the certificate dated 3/9/2021, did not take into consideration the office memorandum dated 8/9/1993, which holds the field. The legal counsel for the petitioner, drawing the reference to the office memorandum dated 8/9/1993, submitted that the petitioner's mother would come within the ambit of Group B service, class 1 or class 2?
Class 2, my lord. Class 2.
Class 2 officer. Whereas the petitioner's father would come within the ambit of class 3 officer.
Class 3. As per my lord, rule 3.1a, 1A and 3B of my lord, provincialized service rules, my lord, 2018.
In terms with
In terms with Assam Secondary Education Provincial
section,
Secondary and Provincial Service Rule
in
2018.
terms with rule 3.1 B, no, 3.1C. No, graduate teacher is, you're not a postgraduate teacher.
Postgraduate teacher, her mother
Mother
is postgraduate. Lordship.
Huh?
Mother is postgraduate. Lordship.
But in your affidavit, it has been shown as graduate.
No, Lordship. Mother is postgraduate. Lordship.
See your affidavit at page 13.
Paragraph 6, Lordship. In the present case, petitioner's mother is a class 2 officer being postgraduate teacher.
Oh, postgraduate. No, no. Where is it class? Oh,
Lordship 6. Paragraph 6.
Oh, post is there. huh?
Post is above.
Mother is a class 2 officer being postgraduate teacher. Postgraduate teacher, bracket subject teacher, and father is a class 3 officer, graduate teacher. Last line to ki kolu? Where is you become within the ambit of class 3 officer? No, mother would come within the ambit of class 2 each officer, and the father would come within the ambit of class 3 officer, as could be seen from rule 3.1 B and C of the Assam Secondary Education Provincialized Rules, Provincialized School, bracket service rules, bracket, oh yeah, Assam Secondary Education, bracket provincialized to agote aigoti, bracket hobo. Provincialized school is bracket service rules 2018. It is therefore the case of the petitioner that the petitioner would not come within the ambit of the schedule to the office memorandum dated 8/9/1993. Accordingly, the action of the respondent authorities to revert the certificate, OBC NCL certificate of the petitioner dated 3/9/2021.
Page 58.
Was contrary to the office memorandum dated 8/9/93, which was holding the field. Next. The submissions were made by the petitioner finds support with the explanations so given to the notification office memorandum dated 8/9/1993 by the Deputy Secretary, by the respondent number 3 in its affidavit in opposition. In paragraph number 3 of the said affidavit in opposition, it was mentioned that category 2 bracket service category of the schedule attached to the OM dated 8/9/1993 provides the criteria for determining creamy layer status of sons and daughters of persons belonging to the OBC category and working in the central and state government or in organizations where the equivalence of posts vis-a-vis posts in central/state government have not been established. In the said paragraph, it has been mentioned as to when the sons and the daughters of class 1 officers of all India central and state services direct recruits are considered falling in creamy layer. It has further been explained as to when the sons and daughters of class 2 officers of central and state services direct recruits are considered as falling in creamy layer. Relevant to take note of that in the case of class 2 officers of central and the state services, to be not entitled to the creamy layer, both the parents have to be class 2 officers. Semicolon. In case of parents of which only the husband is a class 2 officer and he gets into the class 1 at the age of 40 or earlier, is excluded. Semicolon. Parents, both of whom are class 2 officers, and one of them dies or suffers permanent incapacitation, and either one of them has had the benefit of employment in any international organization like UN, IMF, World Bank, etc., for a period of not less than 5 years before such death or a permanent incapacitation is excluded. And parents of whom one is a class 1 officer, bracket direct recruit or pre-40 promoted, and the other is a class 2 officer. And such parent who is class 2 dies or suffers permanent incapacitation. It was also further mentioned that in case of sons and daughters, whose parents, both of whom are class 2 officers, and one of them dies or suffers incapacitation, permanent incapacitation, semicolon, or parents, both of whom are class 2 officers, and both of them die or suffer permanent incapacitation, even though either of them have had the benefit of employment in any international organization like UN, IMF, World Bank, etc., for a period of not less than 5 years before the death or permanent incapacitation, would not come within the ambit of the creamy layer. It has been further mentioned that the category 6 would not apply it was further mentioned that in respect of category 6, which pertains to the income oblique the wealth is, the gross annual income of 8 lakhs or above, or possessing wealth above the exemption limit as prescribed in the Wealth Tax Act for a period of 3 consecutive years, would not be entitled to the creamy layer but in that case, the income from salaries or agricultural lands shall not be clubbed. In such cases, the income has to be taken from other sources of wealth, which would bring them within the purview of income oblique wealth criteria. In view of the said in view of the above, the central government in this notification, taking into account that the petitioner's mother is a class 2 service and the father belongs to the class 3. The mother is a class 2 officer and the petitioner's father is a class 3 officer. As per the Assam Secondary Education Provincialization of School, Provincialized School Rules, Service Rules 2018, have categorically stated in paragraph number 6 that the petitioner would not come, the petitioner being the son and daughter of a class 2 officer and class 3 officer, would not come within the ambit of the creamy layer, OBC creamy layer. Next. The learned counsel appearing on behalf of the respondent number 4 and 5, against whose impugned actions the present petition has been filed, duly submits that the state authorities ought to have read, ought to have taken into account the office memorandum dated 8/9/2000, 1993, in the perspective as have been explained in the affidavit in opposition by the respondent number 3. Full stop. Mr. Dhar, anything?
No, my lord, this is the law. This is the proposition, my lord. Why am only?
Mr. Ardha appearing for the respondent number 1 and 2 also supports the stand of the respondent number 3. Taking into account the above, this court therefore disposes of the petition, observing that the petitioner would not come within the ambit of OBC creamy layer on the ground that the petitioner's mother is a class 2 officer and the petitioner's father is a class 3 officer. Accordingly, this court therefore directs the respondent number who?
My lord, 4 and 5, my lord.
Give anybody one.
The deputy commissioner. My lord.
Huh?
Deputy Commissioner Morigaon also is number 4.
Therefore directs the respondent number 4 to forthwith, upon receipt of a certified copy of the instant order, issue the OBC non-creamy layer certificate to the petitioner, and not later than 15 days therefrom. With the above the petition stand.
DPO. DPO.
Top of the list matters out.
Number
10.
Public.
10. Yes, madam.
Petitioner is challenged the my lord transfer order, my lord. Petitioner is the my lord senior medical and health officer, my lord. He has been transferred by the deputy commissioner, my lord. And on the last of the 2 occasions, my lord, instruction was sought by this honorable court as to whether the deputy commissioner has the authority to transfer a doctor, my lord. So
Where's the order of transfer?
instruction is awaited, my lord.
This one, page annexure G,
Annexure, my lord, and page 38, my lord.
page 37.
37 and 38.
37
both.
and 38.
And we have filed our affidavit. Apni poa nahi nahi.
In partial modification of, yeah.
Affidavit.
What's your name?
Dr.
Dr.
Ashraf.
Hanif Mohammad Afsar Alam Loskor. What do you have, law? Dr. Afsar Alam. Huh? Hanif is missing. Oh, in the next one it is there.
My lord, 37 is the first order and 38 is the modified order, my lord.
Oh, maybe because of the name is not properly written.
Some other,
Annexure G says, in the interest of public service, patient care, Dr. Afsar Alam, medical and health officer, SM Dev Civil Hospital is hereby transferred and posted by so-and-so senior with immediate effect. Both the officials are directed to report for duty at their new place of posting immediately. Then in partial modification of demand and in the interest of public service, Doctor, now the proper name comes.
yes,
Hanif Mohammad Afsar Alam Loskor, Senior Medical Officer, so-and-so, Model Hospital, currently attached at so and so is hereby transferred and posted to Katigora Model Hospital, Kachar, with immediate effect. Vice Dr. So and so transferred and posted to SM with immediate effect. Yes.
In this case, the respondent were.
Your only case is that the deputy commissioner doesn't have the authority.
Your lordship may kindly see the last two orders dated 9/5/22 and 1/6/22, my lord, orders of this honorable.
Of this court.
We have filed our affidavit, Lord.
Understood.
My lord,
Tell me
this
whether the
apart
deputy
from
commissioner
my-
has the power. We are
Lordship,
only on the power, Madam, we are only on the power.
Lordship,
Yes.
regarding transfer, there is no such power.
Then we set
But-
aside.
But Lordship, if your Lordship go by paragraph, our paragraph 4,
No,
it was
Isn't
mistake.
he an employment of health department?
Yes, my lord.
No, he is also holding the post of chairperson, district health society. And in our paragraph 4, we have stated that it was mistakenly mentioned as far as posting, it should have been allowed to work. In respect of the petitioner, respondent number 7, so and so, the arrangement was made only to improve the delivery services, especially
No,
the cesarean section.
Can the chairman direct district health society ask him to go from there to there?
No, it's a temporary arrangement.
No. What is this temporary? There is no transfer. You see, we come
That
under
is-
that Mohinder Singh Gill's judgment. We set aside. You
That
do.
is the stand
If
taken
they
in the
want to
affidavit.
do it. What is this unnecessary?
That is the stand taken in the affidavit.
No. This can't happen. Yes, health is.
No, he has not come to the scene till yet, Lordship, because it is done by the deputy commissioner.
No, understood. Does he have the power?
No, my lord, because the appointing authority is government, my lord, and government.
Government means which government? Health department.
Government in the health and family welfare.
So they have no power.
No, my
Okay, I pass the order to set aside this.
Lordship.
You take a fresh decision, keep on doing it.
Lordship, Lordship,
Okay,
yes.
better. I'll pass the order in your presence.
Lordship. Much.
What about the other person? Is he a party?
Yes, my lord, he is the party, my lord. Order number 7.
And no notice has been issued till now.
No, my lord, only instruction was sought whether the deputy commissioner has the authority to my lord, transfer a doctor, my lord. So that instruction was awaited, my lord, so no notice was issued, my lord.
Heard Miss S.B. Chaudhary, the learned counsel, appearing on behalf of the petitioner. Mr. H. Sharma appears on behalf of the respondent numbers
1 and 6.
1 and 6. Miss S. Sharma appears on behalf of the respondent number 2,
2, 3, 4, 5.
4, 5. The instant writ petition has been filed challenging the order of transfer dated 3rd of March 2022, issued by the Deputy Commissioner cum Chairman District Health Society, Kachar, specifically on the ground that the Deputy Commissioner cum Chairman District Health Society has no authority or jurisdiction to issue the said transfer order. Taking into account that the transfer order have been issued, that the question involved pertains to a transfer order being issued by an authority having no authority or having by an authority who has no powers to do so. taking into account the question involved, taking into account the question involved. No, itu episode 3. It appears on record. This court, by an order dated 17/3/2022, sought for instructions from the respondents number 1 to 6, and further state the orders dated 1/3/2022 and 3/3/2022 issued by the respondent number 6. The said interim order has been continued from time to time. And a writ petition was last listed on 31/10/2022. It further appears on record that the respondent number 6, who issued the transfer order, had filed an affidavit in opposition. In paragraph number 4 of the said affidavit in opposition, it was mentioned that due to clerical mistake in the order dated 1/3/2022 and the order dated 3/3/2022, it was mistakenly mentioned as transfer and posting. It should have been allowed to work. In other words, the respondent number 6 duly admits that the said authority did not have the power and jurisdiction to transfer the petitioner. This court at this stage finds it relevant to take into account the judgment of the Supreme Court in the case of Mohinder Singh Gill versus. Yes, madam. Which one do you want to rely? Mohinder Singh Gill versus Chief Election Commissioner. Finds it relevant to refer to the judgment of the Supreme Court in the case of Mohinder Singh Gill and another versus the Chief Election Commissioner, New Delhi, reported in 1978 1 SCC 405, wherein at paragraph number 8, the Supreme Court observed that when a statutory functionary makes an order on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of an affidavit or otherwise. It was observed that otherwise, an order bad in the beginning may, by the time it comes to the court on account of a challenge, gets validated by additional grounds later brought about. Paragraph number 8 of the said judgment is reproduced herein under. This court further inquired with the learned counsel for the health department as to whether in the present case, whether the deputy commissioner come chairperson, district health society has the authority to transfer the petitioner. It was the categorical submission of Ms. S. Sharma that it is only the government of Assam in the Health and Family Welfare Department who could transfer and post the petitioner, and not the deputy commissioner, come chairman, district health society, as have been done by the orders impugned in the instant proceedings. Next. Taking into account the law laid down by the Supreme Court in the case of Mahendra Singh Gill Supra, wherein it has been categorically mentioned that the order that when a statutory authority makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons. In the shape of an affidavit or otherwise. The explanation given in paragraph number 4 of the said affidavit is nothing but an explanation so given which has no nexus with the orders impugned in the instant proceedings. Accordingly, therefore, the impugned orders are set aside and quashed. Orders dated 1/3/2022 and 3/3/2022. 1/3 does not survive. 3/3/2022 are set aside and quashed. Before parting, this court further finds it relevant to take note of, to observe that the instant order so passed by this court is without notice to the respondent number 7. Inasmuch as it is no longer res integra that no person can claim a right on the basis of an order passed by an authority who has no authority. With the above, the petition stands.
Petition allowed, Lord.
Disposed?
Lord. No, I have heard dismissed, Lord, today. I'm sorry, Lord.
Item 1 and 2.
Yes.
My lord, had gone to the petition, my lord. Basically, it's covered, my lord, now I find.
Covered?
Yes, lordship in favor of the petitioner, my lord. Only thing is the revenue stand is they have filed in a connected matter, they have filed an SLP, my lord, SLP is pending. So, my lord, this honorable court has passed that order. It is on the interest component, my lord. There are two division bench judgment of our High Court. Okay, 35655 equal to 35655 amount is different. Amount. K2.
In both the requisitions, same question.
Yes, lordship. Initially, my lord, jurisdictional assistant commissioner rejected our claim. Then an appeal was preferred before the commissioner. Commissioner allowed our appeal. Against that, my lord, the revenue went to system. System rejected. That is how, my lord, the money was paid. Refund was made, but the interest was not.
And where is the main judgment?
Of
Here, Mr. Kyle, you have only given the,
Yes, very yes.
huh?
Today I have not brought that. Yeah, Lordship, there was one writ appeal, another Central Exchange appeals.
No, there's a writ appeal 160 of
Yes, Lordship,
2021.
in the writ appeal, Lordship, that was allowed in favor of the petitioner, asking us to make payment of the interest on the Central Exchange exemption. That was the question involved in that. Against that, we prepared appeal, and in the meantime, another 5 appeals were filed by the department, Lordship, challenging the order of the CSEC, where interest was allowed. So this common order was passed.
Understood, but this is in respect to a order being passed in writ appeal 160 of
Yes,
2021,
Lordship, that writ appeal was allowed in favor of the petitioner, Lord,
thereby directing,
to make payment of interest. Lord.
and there was no direction for subject to outcome.
No, Lordship, that was simple order was passed allowing the writ petition.
And against that, you have challenged it.
We preferred writ appeal, Lordship.
You have prepared the SLP.
SLP, Lord, there is another case, Lordship.
Huh?
Same question of law was involved in that SLP. Initially, Lordship, amalgamated judgment was passed by this honorable court, the division bench.
This is
said
the one,
that
my lord,
under 11
reported case. 2013 2 GLT 41.
under section 11 double B, we are the department is required to make payment of interest on the delay payment of excise duty. That we preferred appeal, but that was rejected. In the meantime, again order was passed against we preferred appeal, that is admitted, but however there is no stay order. Lord.
2018.
Yes, Lord. That is still pending. Lord.
In fact, my lord, there are 2 judgments of this on division bench judgment, whereby, my lord, it said the assessee is entitled to interest, even in case of a refund under that exemption notification.
And in that amalgamated, Lordship, Honorable Supreme Court dismissed our appeal, but the question of law was kept open.
SLP dismissed.
Yes, SLP dismissed with the question of law was kept open. Lord.
In it to be decided in an appropriate case. So as on date, my lord, amalgamated plantations case, more
Yes,
or less, my lord, until, can I pass over the judgment?
Yes, yes. We have a lot of here.
My lord will kindly have a look at para 20.
No, I am otherwise not worried. I am only worried with can an order be passed by this court and be subject to an outcome of another
My
proceeding?
lord, that's what I was telling my learned friend, it can't be. Because until and unless, my lord.
Unless res
this
judicata would not-
lordship, the order which your lordship will pass and is specifically challenged, that order will attend finally.
Yes, unless it is not
That is what I
challenged.
was telling my learned friend. That's the law. There are so many judgments on this point.
That is the why I am asking.
Yes. So that
I can
makes no
pass an
sense.
order to that effect, but how can I pass an order which, with due respect, the division bench has?
Yes, yes. That is what I was precisely telling my learned friend.
Lordship, another writ appeal, similar type of order was passed by the division.
Understood, but that
My lord,
court
even
was.
there are Supreme Court judgments. Supposing, my lord, there is an X judgment.
No,
Relying on X
you
judgment,
see,
Y judgment
I
is
can in my fingertips say that the judgment of the Supreme Court in BSNL versus Union of India, 2006, 3 SCC page 1.
yes.
It categorically says that once it is final for that.
Lordship, another judgment is that today I have not brought.
It's a different matter. Following that order, this can also be overturned. But it has to be appealed against.
Otherwise, wouldn't res judicata apply?
Lordship, there is
Unless, he agrees. That, yes, I am willing to give an answer.
And Lordship, in these cases, Lordship, we have,
There, the learned counsel must have said, we are willing.
yes, Lordship, that is recorded also.
That is why it is given. That we are willing. We will refund
I
it.
think my learned friend will appreciate, assuming, my lord, the order of the Honorable Supreme Court is, given in favor of the revenue. That by itself, my right will not evaporate unless the order which your lordship will pass, that is appealed against in a higher court.
Yeah.
That is the law, my lord.
No, that is the law. Unless you agree.
Yes, sir.
You say that, okay, I will agree with this order.
My lord will go by the amalgamated plantations judgment, my lord, where it is clearly said, issue is covered, my lord.
No, we are also not disputing
In
about.
fact, that Rainback's case in Supreme Court, my lord, relying on that, where the Honorable Supreme Court says, when it comes to interest, it applies to any refund. The emphasis was on any refund. In Rainback's case, my lord, there is a circular of the government regarding payment of interest. It says, in this connection, board would like to stress that provision of section 11 BB of the Central Excise are attracted automatically for any refund sanction beyond period of 3 months. Rainback's case. my lord.
Now, what do you say, Mr. Chaudhary? Do you agree with?
Naturally, I'll not. Why should I give an undertaking, my lord?
No, it is there. I have seen all written arguments. Everything is here. The Renbeck say everything is here.
Yes,
Just now I could see some written arguments. Everything is here.
Yes.
no, that written argument was given by learned friend, my lord.
Huh?
Argument was given by my learned friend, not by us.
Probably petitioner also filed. Yes.
It is
Both-
there.
Both the parties have given.
Brahmaputra carbon, it is given there. Na? You have the written argument. Everything is here. Yes, amalgamated plantation.
3 years old, we forgot everything, my lord.
Item number 2 of 27. One B Sharma has filed it.
My lord,
Yes,
people,
Lordship.
Sharma.
Department has also filed lots.
আমি ফাইল করা নাইনি
Yes.
বলছি মোৰ মনত নপৰে মই দিয়া নাই that was education says.
Because that day, while that matter was taken, na, Mr. Kotoki was there. You were there initially, moved it, and Mr. J. Patwari was appearing.
Yes, yes, yes.
I specifically asked him, are you giving the undertaking? He said, yes. So that is why I gave it.
No, that was before this honorable court, my lord.
No, 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 no,
But
no,
before,
no.
no, in the other matter,
No, that judgment was given by Justice Michael Chuthankuma, which went to the division bench.
yes,
Division bench said that they
we
shall
will not
give
stay,
it.
we will
We are not
stay.
stayed, but he will give an undertaking. Now, therefore, the question was as to whether you are going to give the undertaking. He said, I am giving. That is why I dispose of the matter. That is it.
That ACB matter, APDCL matter,
Yeah.
pension.
So what do you say? If you have to give an under, you have to take instructions.
Of course, my lord.
Otherwise, this has to be disposed of. If there is no stay
Yes,
in the light of the division bench order.
yes.
Where is the division bench order?
No, final.
Not this
No,
one.
no, final one.
This is only
Yes, yes.
an order by which it's consequential. And the council appearing out there had expects. He said that he is willing to give.
Yes, Lord. Division bench
In
order,
that
Lordship,
case, my lord, let us have the instruction on Monday, my lord.
Yes, I think better off.
My lord.
If you can have it on Monday, then
Yes, yes, Monday, Monday.
Otherwise, because he may be willing to.
Of course, that's right. Oh, okay.
Otherwise, I will dispose of in terms with the division bench.
Lordship can reserve the order. Only thing is, my lord, we will convey to Lordship the parties stand in the matter regarding whether they would like to give an undertaking.
Mr. Chaudhary, no reserving business because the reserving is a very difficult. The problem which I am having
No,
is
I followed.
after dictating all the judgments, these have to be corrected, and after it takes a long time. No reserving.
Monday.
Heard Mr. Kane Chaudhary, the learned senior counsel, assisted by Mr. A. Das. The H.C. Kyle appears on behalf of the respondent. GST. It has been brought to the attention of this court that the issue involved herein is covered by the judgment of the division bench of this court in the case of Amalgamated Translation
Plantations.
P Limited versus Union of India, reported in 2013 to GLT 413, wherein it has been held.
Para 31, I think.
That section 11B of the Central Excise Act
It will be double B.
does not exclude claim of double B of the Central Excise Act. This is capital B, no?
Capital B.
Capital B, double capital B of the Central Excise Act 1944 does not exclude the claim of refund made in terms with the notification dated 8/7/1999. And therefore, the petitioner would be entitled to interest under the said provision on the excise duty refunded to them. The learned counsel appearing on behalf of the where is that order? Appearing on behalf of the appearing on behalf of the GST, Mr. S.C. Kyle submits that the department has preferred an appeal pending before the Supreme Court, which have been registered and numbered as SLP number 016322/2018, and the same is pending disposal. The learned counsel for the GST further submitted that the division bench in subsequent later matter while taking into account similar issues have directed the departments to pay the interest on delayed refund to the respondent assessees within a period of 2 months However, subject to an undertaking to be given by the SSC that in case the revenue succeeds in the said SLP, the interest amount paid under this order, under the order shall be reimbursed to the department. Mr. Ken Chaudhary, the learned senior counsel, submits that taking into account the question of taking into account that a question of undertaking has to be given, it would be appropriate that the petitioners take instructions from their clients, it would be appropriate for the councils to take appropriate instructions from the petitioners as to whether they are willing to give the undertaking. Accordingly, list the matter on Monday, 2 p.m.
Well, lots, deeply.
No, I have no 2 p.m. These are top of the list. You will come top of the list. To my
Item 11.
Ali bondho ache na. Yes.
The matter relates to disbursement of area salaries. It is an admitted position, Lordship, because they admit that the area salary is due, but due to the shortage of the funds, they have not been able to disburse.
Lordship, I have instructions in this matter.
Fantastic. Tell me.
Lordship, we have processed it, Lordship. Today I have received the instruction, my lord. I have produced it, my lord. We have sent it to the finance for sanctioning, my lord.
No finance.
Finance department, my lord.
Finance is not here.
At the moment, they are not here, my lord. But today only they have sent the letter, my lord.
Petitioner is allowed to implead finance department of the state as respond number respectively. Petitioner transfer has entered appearance. No finance. My goodness, no finance. When is this due?
It is due, my lord, since 16/11/2009 to 1/5/2013.
No. When was it due? Are you retired?
No, my lord, I am working, still working.
How much is the amount?
Amount?
1,87,000.
No, my lord. As per their calculation, if my lord comes to page 24, page 24 of the writ petition, as per their calculation is 3,12,847. And as per the calculation of mine, it is 3,66,891.
No, here is a case where they are asking for how much? First salary proposal in respect to WPC numbers so and so, and for the period from 8 to 2006 to 23 year, along with relevant information. How much amount you are giving?
My lord, as far as we are concerned, my lord, this is the instruction which is received, my lord.
This instruction is not proper.
My lord, I'll get the updated one, my lord.
When?
My lord, give me, my lord, a week's time, my lord.
This is in the motion.
No, we're still in the motion, my lord.
My goodness, that is the reason why this has happened. Okay, these people actually with the motion, nothing happens like this. If you heard Mr. NBP Sinha, the learned counsel, appearing on behalf of the petitioner. Mr. A. Pukon appears on behalf of the respondent numbers 1, 2, and 3. None appears for the finance department on call. On behalf of the respondent number 5, 4, and 5, that is the finance department on call. Issue notice making it returnable on 24th of July 2023. As the respondent numbers 1, 2, and 3 are duly represented, extra copies of the writ petition be served upon them by 29th of May. As regards the respondent number 4 and 5, the petitioner is given the liberty to serve an extra copy of the writ petition So serve extra copies of the petition upon a standing council of the finance department. The case of the petitioner herein is that the petitioner is entitled to the area salary for the period from 16/11/2009 to 1/5/2013, which amounts to rupees 3,66,891. This salary is in respect to when the petitioner was under suspension. The respondents in the elementary education department shall apprise this court as to why the said amount has not yet been paid to the petitioner. Full stop. Liberty is given to the petitioner to mention the matter for upgrading. The registry shall also show the name of Mr. Arbor Pujari, show the name of SC Finance in the cause list.
For motion, item 12.
This petition is basically praying for direction to be issued to the housing board for payment of referral benefit. In this case, affidavit was filed. On the basis of the affidavit, in fact, petition was disposed of by an order dated 13th of December. But in the order, and as well as in the schedule provided in the affidavit, there was a variance. And accordingly, an IA was filed by the petitioner for correction of that order. But while taking up the IA, this honorable court holds that since the IA will not serve the purpose as the schedule has already term has been expired.
Of what is expired?
So the undertaking was given in the affidavit that first installment of 1 lakh will be paid by 20th of December. So since that part was not incorporated in the order, was not reflected, the petitioner filed an interlocutory application. But while taking up that matter, the court came to a finding that, my lord, since time has been passed, therefore it was.
There is an affidavit filed.
Yes, my lord. Affidavit has been filed, my lord.
What is this affidavit? Who has filed? 2 and 3. Who is 2 and 3? Commissioner. Oh,
Housing board, Lords.
Mr. Gogoi. Yes, tell me.
My lord, they are scheduled. They have stated.
When are you paying? Oh, that matter, similar matter.
Similar matter, Lordship.
To dispose it of.
Yes, my lord.
Directing you to pay in installments. That 12 months.
Yes, Lordship. I have taken the earlier order, Lordship.
12 months.
Lordship.
Order. Dispose it of.
One aspect, Lordship, may kindly consider for a moment. Lordship may kindly come to page 19 for a minute.
You are entitled to how much?
My lord, according to them, in their affidavit, they have stated 6,62,646. My lord, Lordship may kindly come to page 19 of my repetition. Wherein on which, my lord, dated 12th of May 2022. This is for release of, my lord, being the area annual increment. My lord, while taking the computation, had this area been taken into account, there would be some increase in the gratuity and other payable, my lord, in my respectful submission. So they may be directed for recalculation on the basis of the area increment, my lord. That has not been reflected in the affidavit, my lord.
You do one thing. We should notice.
Lords.
To you, you come up with an affidavit stating as regards whether you have taken into account the area, taken into account the increment, any area annual increment. If you have taken it or not, and give your calculation how you have arrived at 6,62,000. Because if you remember, this matter initially they had given calculation. Now in the affidavits they are not giving it.
Lords.
How this amount was arrived at.
Lords.
And if necessary, as to whether you have taken into account the annual area. Okay.
Okay.
Heard, Mr.
D. Chakraborty.
D. Chakraborty, the learned counsel appearing on behalf of the petitioner, Mr. T.R. Gogoi, na?
T.R. Gogoi, Lords.
Appears for the respondent number 2 and 3, Ms. M.D. Shah, Ms. M.D. Bora appears on behalf of the respondent number 1. Issue notice making it returnable on how long?
2 weeks, Lords.
Returnable on 23rd of June,
Lords.
2023. Extra as the respondent numbers 1, 2, and 3 are duly represented, extra copies of the petition be served upon them, upon the learned councils by 29/5/2023. It appears from the records that the Commissioner of Assam State Housing Board, that is the respondent number 2 and 3,
2 and 3, Lords.
have filed an affidavit on 6/12/2022,
Lords.
thereby admitting that the petitioner is entitled to an amount of gratuity on account of gratuity, area increment, and leave encashment benefit of an amount of rupees 6,62,646. It has been further mentioned that the respondent number 2 and 3 is willing to pay the said amount in installments, taking into account the financial status of the respondent corporation, respondent board. The learned counsel for the petitioner, however, submits that from the affidavit, it is not clear as to on what basis the said amount of rupees 6,62,646 have been arrived at. And why the petitioner otherwise is not entitled to rupees 7,50,752. Referring to the office order dated 12/5/2022, the learned counsel further submits that the petitioner was entitled to the area annual increment for the period from 1/7/2018 to 31/1/2020. It is therefore the case of the petitioner as to whether, while computing the entitlement of the petitioner, the area annual increment has been taken or not is to be taken into consideration. The learned counsel, appearing on behalf of the respondent number 1 and 2 and 3, submits that the respondent board shall file an affidavit detailing out as to how the amount of rupees 6,62,646 have been arrived at, and also, if necessary, recompute and place it before this court. Let the said affidavit be filed by 21st of June. Filed by 21st, we'll take it over there.
13.
Yes, Mr. Goswami.
Relating to the suspension order, it was suspended by the order at page 16, my lord.
So what remains?
For instance, the representation submitted on 21/2/2023. This 90 days period is over, so he may be, my lord, reinstated as per the your
I am to
order.
inform you that the service in respect of Puento under suspension yet to be reinstated due to non-receipt of the detailed report from the CBC. But madam, tell me one thing.
My lord,
Where is the memorandum of charge?
they are not.
It's set aside.
My lord, but
we-
Liberty may be give us to continue the DP, my lord.
Huh?
Liberty may be given us,
For?
continue the DP.
Absolutely. But where is the DP has not started?
That's
In fact, Lordship may kindly have a look my letter which I have written to them. I have explained.
You were arrested?
Yes, my lord.
Arrested. I have written everything in this letter, but they did not take.
Even I would like to inform you that the matter came up. Madam, you didn't ask them to issue the memorandum of charge.
Because they have not done, I have called them also, my lord. Email
Then
them.
I can't help you.
Yes, Lordship may pass appropriate order, but liberty may be given to us to continue the proceedings.
That you are. Heard Ms. R. Goswami, the learned counsel appearing on behalf of the petitioner. Ms. N. Bora appears on behalf of the
2 and 3,
respondent
my lord.
numbers 1, 2, and 3. No, 2
Lordship,
and
2
3.
and 3 I have.
As Doctor appears for the respondent number 1. The case of the petitioner herein is that the petitioner was arrested in connection with ACB PS case number 42/2022 under section 7A of the Prevention of Corruption Act 1988. Arrested Dittu Koloni were arrested on 23/9/2022 in connection with ACB PS case number 42/2022 under section 7A of the Prevention of Corruption Act 1988. Thereupon, the Deputy Commissioner come disciplinary authority by an order dated 26/9/2022 put the petitioner under suspension in exercise of the power under Rule 6(2) of the Assam Discipline and Appeal Rules 1964. Discipline and Appeal, break it up. The petitioner was released on bail by an order dated 7/10/2022 by this court in bail application number 2604/2022. Thereupon, on 21/2/2023, the petitioner submitted a representation to the Deputy Commissioner Nagaon intimating that he had been released on bail and in terms with the judgment of the Supreme Court in the case of Ajoy Kumar Chaudhary versus Union of India reported in 2015 7 SC 291. The petitioner ought to be reinstated. Thereupon it reveals that the petitioner filed a writ petition before this court challenging the order of suspension And the same was registered and numbered as WPC number 770/2022. Right. এইটো ইনফৰ্ম কৰাৰ আগতে দেই তাৰ আগতে লিখিব এইটো সাসপেন্ড হল ৰিলিজ হল on bail, huh? Then he would write. The petitioner immediately thereafter filed a writ petition before this court. Is it the same person?
No, my lord, it's different.
Something different.
Similar order was passed in
Oh,
7.
why you are enclosing this one?
Similar order.
You want this order?
No, my lord.
I can give you this order. I'll be happy to give you.
That order passed by Rafid Ali Ahmed, but
No, we give you.
that
This,
Rafid Ali Ahmed.
no, we give you. Hiranya
Similar order.
Huh?
Similar order was passed in a similar case, my lord. But this, your lordship passed then.
এইটো নহয়,
Rafid
ঠিক
Ali
আছে, had duly informed on 21/2/2023 হেতুলৈকে লিখিলে হা এইটো তাৰপিছত repetition challenge thereafter the petitioner filed the instant writ petition on 25th of April 2023 challenging the continuation of the said suspension order being in violation to the judgment of the Supreme Court in the case of Ajoy Kumar Chaudhary, the division bench judgment in the case of Rakibuddin Ahmed versus the state of Assam, as well as the office memorandum dated 4/2/2020 issued by the Chief Secretary to the government of Assam and clause 2.1.8 of the manual of departmental inquiry issued by the government of Assam in its personnel department. On the same day, the instant writ petition therefore came up before this court on 28/4/2023. On the same day, this court inquired with the petitioner as to whether a period of 3 months have elapsed from the date you of informing the disciplinary authority that he has been released on bail and or otherwise not in imprisonment or custody. Under such circumstances, the learned counsel submitted that the period of 3 months would, from the date of the communication, would be over on 21/5/2023. And accordingly, this court therefore directed the instant writ petition to be listed on 26th today, that is on 26 May 2023. In the meantime, the learned counsel appearing on behalf of the respondent, Ms. M.D. Bora, had also apprised the respondent authorities about the filing of the instant writ petition. Full stop. Today, the learned counsel appearing for the respondent number 2 and 3. Madam,
My lord.
this is an instruction of 28/4. How can I dispose of this?
Today they have sent to me.
No. This is of 28/4.
This my instruction letter, communication letter 28.
Oh, your letter. Where is that other one? Oh,
The other
oh.
one is
Today, the learned counsel appearing on behalf of the respondent number 2 and 3 placed on record a communication issued by the additional Deputy Commissioner Revenue, wherein it has been mentioned that the petitioner is yet to be reinstated due to non-receipt of the detailed report from the CM Vigilance Cell till date. However, departmental proceedings and extension of the suspension against him is under process. Madam, can you inquire with them? We'll pass the order after some time
My lord.
as to whether the memorandum of charge has been
No.
given.
5 minutes or something.
Yes, we'll take it. Huh? Yes.
Item 14.
So my case is also almost similar to the previous case.
Previous matter,
I-
you have got your memorandum of charge.
No. No
When
review,
did you
no-
inform?
No review, no extension. Lordship.
Huh?
No review, no extension. I was placed under suspension on 18/12/2022. I was released on bail. On Lordship, 19/1/2023.
19?
19/1/2023.
When did you inform?
Lordship, my information, Lordship, my application is 6/2023.
We'll take up this matter because she's already taking up the other one. Na? Let her come back. Because this court is going to issue notice in this matter.
But in this case.
Oh, this is a different department.
Different department.
Elementary.
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 Yes, madam.
No.
No.
No. Never.
ये ही नहीं लिखा होता। ये लिख ले last line too. And the learned counsel further on inquiry apprised this court that till date the memorandum of charge oblique the charge sheet has not been served upon the petitioner. Taking into account the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary, wherein it has been specifically mentioned that the show cause notice oblique the memorandum has to be, memorandum of charge has to be served upon the delinquent employee within a period of 3 months from the date of the suspension order, comma. The judgment of the division bench of this court in Rakibuddin Ahmed Supra, wherein the Supreme Court, wherein the division bench applied the principles of Ajay Kumar Chaudhary to the principles of to a suspension, to a deemed suspension done under Rule 6(2) of the rules of 1964. And further, the judgment of this court in the case of Rafid Ali Ahmed versus State of Assam, reported in so and so, wherein it has been also mentioned that if within 3 months from the date of intimation, within 3 months from the date of intimation, that the petitioner have been released on bail and or otherwise not in custody, the deemed suspension the memorandum of charge is not submitted within 3 months therefrom, the petitioner would be entitled to, the delinquent employee would be entitled to reinstatement in view of the law laid down by the Supreme Court in Ajay Kumar Chaudhary, as well as the office memorandums dated 4/2/2020, wherein it further mandates the requirement of serving the memorandum of charge the charge sheet within 90 days, within 3 months from the date of suspension. And clause 2.1.8 of the manual of departmental proceedings, this court is therefore of the opinion that the further continuation of the suspension of the petitioner would be in violation to the law laid down by the Supreme Court as well as this court and the departmental circulars in that regard. Accordingly, this court therefore directs the Deputy Commissioner to forthwith reinstate the petitioner upon a certified copy of the petition of the instant order being served upon the Deputy Commissioner. However, this court grants the liberty to the state government, to the Deputy Commissioner, Nagaon, to post the petitioner in a non-sensitive post so that in the non-sensitive post, non-sensitive post, so that the petitioner is not in a position to interfere or temper with the investigation as well as the inquiry proceedings proposed. This court further grants the liberty to the Deputy Commissioner, Nagaon, after pursuant to serving the memorandum of charge oblique the charge sheet upon the petitioner, in exercise of the powers under Rule 6(1) of the Rules of 1964, to again suspend the petition if so necessary, that too on the basis after passing a reasoned order.
I'm deeply of this, my lord.
And it will come, instruction may be obtained also.
2 weeks, my lord.
I don't do that, Mr. Counsel.
2 weeks. 2 weeks.
Today is what?
Today is 26th.
26th. Have it on 9th?
9th.
9th, I'm not there, but anyways, will be some other courts. Let you know. Should notice making it returnable on 9/6/2023. The case of the petitioner hearing, and as Mr. A. Pukon appears on behalf of the respondent number 1 to 4, extra copies of the petition be served upon him during the course of the day. The case of the petitioner hearing is that the petitioner was arrested in connection with CIPAZA TS case number 547/2022, registered under section 294 small a oblique 354 capital A, capital Roman 1, small Roman 1, small Roman 2, oblique 506, oblique 34 of the Indian Penal Code, read with section 8 of the POSCO Act. On 18/12/2022. Pursuant thereto, on 20/12 to 29 or 20, on 29/12/2022, the petitioner was put under suspension by the district elementary education officer in charge in exercise of the powers under Rule 6(2) of the Assam Services Discipline and Appeal Rules 1964, with effect from 18/12/2022. The petitioner thereupon was released on bail by this court by an order dated 19/1/2023 in bail application number 3662/2022. Subsequent thereto, on 6/2/2023, the petitioner informed the district elementary education officer about that he should be reinstated. It is the case of the petitioner that till date, the petitioner has not received, have not been served the memorandum of charge and or charge sheet by the respondent, by the disciplinary authority. And as such, in view of the law laid down by the Supreme Court in Ajoy Kumar Chaudhary, Supra, Ajoy Kumar Chaudhary versus Union of India, reported in so and so, the petitioner is entitled to be reinstated. The respondent are directed to apprise this court on the next occasion, on the next date, as to whether the memorandum of charge oblique the charge sheet has been served upon the petitioner, and as to whether there has been compliance to the provision to the law laid down by the Supreme Court in Ajoy Kumar Chaudhary Supra.
This is the deemed suspension law.
Name order. Arrested.
Arrested on lordship 5/10/2021.
Released on bail.
Bail on
23/12/2021. And then
lordship,
when did you intimate?
My family member intimated the senior medical officer about the arrest when I was in custody.
No, when you have been released.
I have been released on 23/12/2021 at page 21.
23/12/2021. When did you inform that you have been released?
No, when I was in the custody, my family member informed.
When did you inform? When after your release?
After my release, I went to the office and I was allowed to join. And then also, while joining, I informed my authorities.
When?
On 2nd of January, 2nd of January 2020.
You were placed under suspension on 3rd of February 2023.
Yes.
Then
I was allowed to work thereafter.
Then why have been again suspended?
Suspension, this is the first suspension order, Lord. 3rd February 2020.
Okay, then
Thereafter, I have filed a appeal before the Director, Secretary Health and Family Welfare Department, Board of Territorial Council at page 26 for that appeal is till then pending. Lord.
heard Mr. Adhar, the learned counsel appearing on behalf of the petitioner. Mr. B. Chaudhary appears for the respondent number
Lordship, all the responding BTC.
1 to 4.
Yes.
To issue notice making it returnable on 9/6/2023. As the respondents are duly represented by Mr. B. Chaudhary, extra copies of the petition be served upon him during the course of the day. The case of the petitioner herein is that the petitioner was arrested
On 5/10/2020.
on
5/10/2021.
when were you arrested?
5/10. Because forwarding letter is forwarding report is of 6 at page 18 Lord.
Was arrested on
Forwarding report watchable file at page 18.
what is the date?
Date is 6/10/2021.
On 6/10/2021 in connection with CADD PS case number 10/2021 registered under section 120B/420/467/468/471. Thereupon, the petitioner was released on bail by whom?
By the
Additional Chief Judicial Magistrate, Kamrup Metro. By an order dated 23/12/2021. After having released the petitioner, joined at the Goresar MPHC as BHW is what? What is BHW?
Basic health worker.
Basic well worker. On 3rd of February 2023, the Director of Health Service, Boroland Territorial Council, in exercise of the powers under Rule 6(2) of the Assam Assam Discipline and Appeal Rules 1964, put the petitioner under suspension with effect from 3/2/2023 on the ground that he was arrested on 6/10/2021 in connection with CIDPS case number 10/2021. The petitioner thereupon filed an appeal on 1/4/2023 before the Secretary, Health and Family Welfare Department. However, to no avail. The case of the petitioner herein is that 3 months have already elapsed from the date the petitioner has been put under suspension, but till date, neither any memorandum of charge and or charge sheet has been served upon the petitioner. And as such, by virtue of the judgment, law declared by the Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India, reported in so and so, the further continuation of the suspension of the petitioner would be in contravention to the law declared by the Supreme Court. The learned counsel appearing on behalf of the respondents shall apprise this court as to whether the memorandum of charge and or the charge sheet has been served upon the petitioner, and as to whether there has been compliance to the law laid down by the Supreme Court in the case of Ajoy Kumar Chaudhary.
16.
This is writ petition is filed for non-payment of due pensionary benefits. Lordship. The Lordship, in paragraph 5, I have quoted the amount which was due to me. CPF was paid. Lordship. Balance amount is still 10,34,643 rupees. That is
Why?
not paid.
Are you getting your regular pension?
No, Lordship. His service was not pensionable. His service was not pensionable. Lordship. He received only CPF, gratuity, and leave allowance.
What are you getting till now? You have got 14 lakhs for what?
That CPF amount, Lordship, in installment they have paid.
CPF you have got. So this is from whom?
From Housing Board. Assam.
Oh, Housing Board. Where is Mr. Gogoi? You have not served a copy.
I have searched copies. I have.
Let's get Cholo. Get him. Mr. T.R. Gogoi. Ask him. Then I can pass the order, na? Otherwise it becomes useless. Get hold.
17.
Yes.
My lord, the petitioner's husband, my lord, and petitioner, my lord, before your lordship, they were husband and wife, and my lord, they changed their faith, my lord. And accordingly, my lord, after changing, my lord, they also changed their name, my lord, in the bank account, my lord. Page 15, my lord. It has become, my lord, Muharram Ali and Sabita Begum Choudhury. The first.
What has happened? The petitioner, what happened?
Then, my lord, they also, my lord, shown one affidavit, my lord, page 16, my lord. It is paper publication, page 16, right hand side of the affidavit. Their names are there, my lord. And
Now what has happened?
my
Why?
lord, then, my lord, his, my lord, pension was, my lord, then stopped, my lord, because of change of name in the, my lord. Then he approached, my lord, before this honorable court. my
He
lord,
or she?
He, my lord, then he, my lord.
Okay.
Pensioner, my lord. Page 22, my lord, order was passed, my lord.
Regarding?
Yes, my lord. It was, my lord, provided that, my lord,
There is no justifiable to stop payment of pension to the petitioner. According, the court directs the respondent number 7 to release the petitioner's pension forfeit along with all area pension within 2 months. Then?
yes, my lord. Now, my lord, he expired recently, my lord. Now, my lord, same problem has come, my lord, to my lord. His death certificate, page 27, my lord. Wife is, my lord, not getting pension. And communication, my lord, from the, my lord, head office of the bank is page 20.
Yes, what is the name?
Name, my lord, now her name, he is Muharram Ali.
I'm not with Muharram Ali. Why it is your, in the PPO, what is written?
PPO, my lord, it was, my lord, then, my lord, it is Muharram Das.
Muharram Das. And her name was?
Sobita Das.
Huh?
Sobita Das.
Sobita Das. Now?
Sobita Choudhury.
Samita Begum Choudhury.
Samita Begum Choudhury. The affidavit, it is reflected, my lord, in the paper.
Hello. And where you have given the representation?
My lord, it was given, my lord, reply of the representation on page 28, my lord.
How did you get this paper?
My lord, this is computer generated, my lord, then, my lord, bank manager gave, my lord.
Where is the mention that you have submitted the representation?
My lord, it is the name of the claimant. My lord, highlighted part, my lord. The name of the
I've
claimant.
seen that, but where is your representation?
it was, my lord, he approached to the bank, my lord.
You have to give the representation. The problem arises there.
My lord.
If they don't do according to the representation, it is a different aspect to the matter. But the problem arises there. You don't give the representation, don't give the representation. Tomorrow I give instruction, then on one fine day you are not there, and there the problem arises. The no representation has been.
You will submit, my lord, representation.
Withdraw this and file a representation out there and state out there that this is whatever you have written in your petition, write everything out there and give all these things, and then we'll take call after that.
And my lord, with the
No.
conservation, my lord, maybe dispose of. That you will get benefit.
Heard Mr. Imbol Bhuiyan, the learned counsel appearing on behalf of the petitioner, Ms. B. Devi.
B Sharma.
B. Sharma appears on behalf of the respondent.
1 to 6.
Respondent numbers
1 to 6.
1 to 6. Madam, this has to be routed through you.
Yes, Lordship. But
You give your representation there, and then they will do the needful. Taking into account that no representation have been submitted till date, before the whom it should be submitted.
to the commandant DDO, respondent number 5, Lordship.
To the respondent number 5,
Or 4, Lordship.
to the respondent number 4. How is the person going to go to the 4? Respondent number 5.
Lordship.
5 is better, nearby.
Yes.
To the respondent number 5. The learned counsel for the petitioner submits that he may be permitted to withdraw the instant petition with the liberty to file a representation before the before the concerned respondents, stating all necessary facts so that the petitioner can get the benefit of the family pension. Accordingly, the instant petition is closed upon withdrawal. However, liberty is given to the petitioner to submit a representation to the respondent number 5, detailed representation to the respondent number 5, as well as the respondent number 7. Give it to 7 also. 7 or 8. From where does the
7 will, my lord, pass without 7, my lord.
7? Taking into account that this being a family pension matter, and the husband of the petitioner was receiving the pension pursuant to orders being passed by this court, the authorities concerned shall duly consider such representation on being submitted.
18.
This is a transfer matter. Then my lord, petitioner before your lordship and constable of an Central Industrial Security Force. And as on that lordship, he is posted in the Bongaigaon IOCL unit, Bongaigaon. And fight ordered at 24/3/2023, page 73 lordship. It is a common transfer order. And this common transfer order petitioner was allotted to the West sector. And his name is reflected in the serial number 2035. Code 74A.
Page?
It starts from lordship page 73. This is a common order.
Yes, what is your problem in going there?
Yes, lordship, that 74A.
Yes.
Serial number 2035 lordship, the Kupon Deuri. He has been allotted to the West sector.
Yes, then?
Yes, and thereafter, lordship, after issuance of this transfer order, I preferred in the representation. Representation is reflected the page 75 Annexure 11. And this representation is still pending. I filed this representation on 10/4/2023. During the pendency of this representation, movement order was issued by the commandant. It's a reflect of page 76. And Lordship, that guideline says I am entitled for the home sector unit since I am belongs to the Assam home sector unit for a period of the 12 years. That 12 years period has not been completed till yet. The guideline is start from page 78.
Where?
Is page 78 annexure 13. 11 is page 80. Clause 2, clause 12.
Page?
Start from page 78. Page 80 is relevant.
Yes.
Yes, clause 12, tenure of posting. And in the middle part, the tenure portion. First 10 years, 7 years, unit out of home sector. Second is second tenure, 12 years in the units in the home sector. I am entitled for the 12 years to service in the state of Assam or in the northeast area. But that 12 years has not been completed till today, Lordship. And therefore, this order is not applicable. Transfer order is there in the law. And my tenure of the posting is reflected, Lordship, that page 6, paragraph 4, the entire period. Initially appointed on 2003. 2003, I was in the Rajasthan. 2003 to 2010, I was in the Jharkhand. From 2010 to 2013, I was in the Bongaigaon IOC. And on 2013, I was removed from the service. I was not in the service from 2013 to 2021. And again, 2021, I was reinstated. And till today, I am serving in the Bongaigaon. So my 12 years has not been completed till today. And as such, I am entitled to serve in the present place of posting. And second, Lordship, that my representation is still pending. And during the pendency, disease and final authority who is decide the issue. And during the pendency of this petition, the commandant has issued the movement order. Lordship, that is my case.
Come to page 80.
Lordship, page 80.
The out of home sector tenure for posting in respect of NGOs are subject to availability of vacancies, operational, administrative needs, and new inductions.
And Lordship, this transfer order is a routine transfer.
Maybe.
Yes.
No, but this is subject to, this is administrative needs. Why should this interfere?
Because my representation is still pending.
No, they will consider. They will bring you back if
And,
necessary.
And that page 79, clause 10.
Yes.
Clause 10A, the Director General shall be the final authority for deciding all such transfer and the postings.
Then?
That is Lordship that's reflected. And as on date, Lordship, I was on the leave. And it is up to the 31st day of May 2023.
And what were you doing for 9 years? You were outside?
9 years, Lordship, my service was terminated by the respondent authority.
Then you have been reinstated.
Reinstated. After initially, I preferred only read appeal. Read appeal was, repetition was allowed. They carried it into the read appeal. Read appeal was in my favor. After decision of the read appeal, I was reinstated in the service.
With?
And, Lordship.
With what did you get? Did you get your back wages?
No, Lordship, till now. For that, I have preferred in the contempt case. In the contempt case, Lordship was disposed of with an undertaking of the council of the respondent that they will abide by the order of, they will comply with the order of a single judge as well as the division bench. But still to the Lordship, they have not paid the 50% of the back wages. When I inquired to the matter, to the respondent authority, they have stated that since I am not working during that period, they are still not given the effect.
So your contempt is pending?
No, one contempt is pending, one contempt is disposed of, second contempt petition is pending till yet.
Very well. But you have got 50% for that.
No, Lordship, till today I not get
You
that.
get it. There's a direction by this
There
court.
is a direction by this.
So why not those 9 years be taken into account?
Lordship, but till today they have not released by the 50%, till today.
So you will get it. One day or the other you will get it.
Even after the decision of the read appeal, they have again issued the disciplinary proceeding against me. I have again approached this honorable court. This honorable court
But
stated.
Mr. Counsel, tell me, where is the vindictiveness?
Lordship, on one hand, they have not followed their own guidelines.
That is subject to.
Yes, Lordship. So, Lordship.
It's subject to. They may, I would have understood if they have singled it out to you. But this was given to everybody.
Yes, Lordship, but Lordship, giving to our direction to obtain the instruction, whether it is a routine transfer, whether the post is available with the IOCL or not. Second question. Third one is, Lordship, that so far my knowledge is concerned, till today there is a vacancy in the IOCL unit.
No. You have been transferred along with others as a platoon or something to that effect.
Yes, they have.
So they have transferred you out there with that. So let them go. No question of interference with this.
Till today, no reliever's report in my place. Till today.
You go there. And the authority, I will only direct the authority to consider your representation, but you are going to go there. Nothing to it. No interference with the transfer.
Yes, Lordship, that till decisions from the respondent authority. So,
Mr. Vesburua, nothing doing. Sorry. I may issue a notice, but if you just issue a notice, nothing happens, you have to go.
Lordship may give direction to the respondent authority to dispose of my representation.
That only I can give. Nothing more. I am not interfering with the transfer order. Because this is done under administrative exchange. And if the department thinks that you can be taken into consideration, they will consider. Heard, Mr.
Again, reliever will come, Lordship.
H. Vesburua, the learned counsel, appearing on behalf of the petitioner, Mr. U. Goswami, appears for all the respondents.
All Rasul, 1 to 6.
All the respondents. The instant petition is taken up from a disposal at the motion stage itself. The case of the petitioner herein is that the petitioner, along with the entire unit, have been transferred from Northeast Zone to West Sector by an order dated 24/3/2023. A perusal of the said order reveals that the individuals have been granted the liberty to file representations on or before 12/4/2023, making it clear that representations received after 12/4/2023 shall not be considered. The petitioner thereupon submitted a representation on 10/4/2023, as could be seen from Annexure 11 to the petition. However, without considering the same, the movement order have been passed by the, who has passed this?
That is the assistant commandant lordship,
By the assistant commandant,
IOCL unit, Bangaigaon, CISF.
by by the respondent number 6. Being agreed, the petitioner has approached the court challenging the transfer order on the ground of non-consideration of the representation as well as also not taking into consideration clause 12 of the circular number 22/2017. A perusal of the clause 12 of the circular dated clause 12 of the circular dated 25/9/2017 reveals that the out-of-home sector and home sector tenure for posting in respect of NGOs are subject to availability of vacancies, operational, administrative needs, and new inductions. Therefore, it would be seen that although a period has been mentioned to the effect that the first tenure to be 7 years, second tenure, the first tenure to be 7 years outside the home sector, the second tenure to be 12 years in units in home sector, the third tenure to be 6 years in outside the home sector, and the fourth tenure bracket remaining of service home sector. But the same is upon the administrative exigency. Same is subject to administrative exigencies. Taking into account that there has been that the transfer order dated 24/3/2023 have been passed in a routine manner without an opportunity of submitting a representation having also been granted on or before 12/4/2023, this court is not inclined to interfere with the order of the transfer. However, this court finds it relevant to observe and direct that if the petitioner had submitted the representation on or before 12/4/2023, the respondent authorities shall consider the said representation and take such measures as deem fit in its own wisdom. With the above, the petition stands disposed.
Much obliged.
19.
Please, Your Lordship. Lordship, in the present petition, the petitioner was placed under suspension on 31st of December 2016, Your Lordship. And thereafter, the show cause notice has been issued on 19th of August 2021, Your Lordship. And in the meantime, no order extending the suspension order has ever been passed. And the petitioner continues to be in suspension, Your Lordship. And suspension.
What is the disciplinary proceedings?
Lordship, the show cause is an.
You have replied also.
Yes, Your Lordship.
What is the status?
Lordship is still under suspension, Your Lordship. In fact, Your Lordship, the petitioner had applied for an RTI also, and therein he has got the information that they were considering to either withdraw his disciplinary proceeding or reinstate him or revoke his suspension and reinstate him, Your Lordship. But thereafter, Your Lordship, on 10th of March this year, Your Lordship, they appointed a state inquiry officer.
They have appointed an inquiry officer?
Yes, Your Lordship. That is in annexure 11, page 66, Your Lordship.
Madam, what is this soil conservation department? You have appointed an inquiry officer on 10th of March.
Yes, Your Lordship.
And how much time you have given? Within 2 months. Have they completed?
My lord, I need instruction, my lord.
Fantastic. Heard Miss
S. Sharma Hazarika, Your Lordship.
S.S. Hazarika, the learned counsel appearing on behalf of the petitioner. Miss R.S. Deori appears on behalf of
Soil Conservation Department, all the respondents.
all the respondents. Issue notice making it returnable on 19 June,
Yes.
19th of June, 2023. As the respondents are duly represented by Ms. R.S. Deori, the learned counsel appearing on behalf of the respondents, extra copies of the writ petition be served upon her by 29th of May 2023. The petitioner is aggrieved by the prolonged continuation of the suspension order and the delay in culmination of the departmental proceedings. The learned counsel appearing on behalf of the petitioners has drawn the attention that on 19th of August 2021, the memorandum of charge was submitted to the petitioner and the petitioner replied to the same. On
10th of September, Your Lordship, 2020.
10th of September 2021. However, it was only on 10th of March 2023. An inquiry officer, the inquiry officer as well as the presenting officer have been appointed under Rule 9.4 and Rule 9.5 of the Assam's Discipline and Service Appeal Service Rules 1964. The respondent in the Soil Conservation Department is directed to apprise this court on the next returnable date as regards the status of the departmental proceedings against the petitioner and also file an affidavit as to whether there has been any review carried out as is required in terms with the circular dated 4/2020. Office memorandum. Huh?
Production list, item number 1 for motion.
Yes, Mr. Bachaji.
Yes, my lord, but this is a
Transferred from where to where?
My lord, the case here is a bit complicated, my lord. Because I like it's a bit complicated, my lord, because I need transfer. Okay, my lord, that's okay. But the question here is, my lord, where I have been transferred, there's no medical facility.
Oh.
My lord, your lordship will come to the page 29, my lord. First of all, my lord, that is page 29, the circular by the government of India, my lord, regarding the disability person, my lord. Guidelines are given.
28.
Page 29, my lord. The operative part, my lord.
Yes.
H, my lord. The item H, my lord, the indication item H.
Yes. Preference for transfer.
For transfer and posting. As far as possible, the person with disability may be exempted from the rotational transfer policy, and transfer may be allowed to continue in the same job where they would have been achieved the desired performance. Further preference is in the place of posting at the time of transfer. Public promotion may be given to the person with a disability subject to the administrative constraint. The practice of considering the choice of place of posting in case of a person with disability may be continued to the extent feasible that they may be retained in the same job where the service would be optimally utilized. My lord, I have a 60% disability, that is my right leg has been amputated. I have been put with the artificial legs. And my only treatment which I need is a Guwahati. Your lordship will see the
Where is the transfer order?
My lord, that is.
27th of April 2022.
Yes, my lord. No, the transfer order is, my lord, at page, page 25, my lord. I am Bipul Talukdar, my lord. That is, I think, serial number 2. I have been transferred to Dibrugarh, my lord.
Oh, Dibrugarh, good place. AMC is there.
Yes, they are there, my lord. But your lordship will see the certificate given by the Indian Oil Company as well as by the company.
BPCL, Mr. Bhattacharya, BPCL has a very good.
Yes, my lord. I agree, my lord.
Then?
But your lordship will see the certificate given by the OIL hospital as well by the Androlite, the person who has put it the artificial lake. They said this is only in Guwahati they have the service.
Which
Nowhere
one?
else.
Which one?
My lord, page 27, my lord.
This is to certify that Mr. So is right below knee amputee and he is using Android flight prosthetic. He is coming on regular basis for follow-up of his prosthetic leg as it is a part of our curriculum. There is only branch of Kerala existing in Guwahati in this one.
As regular
Follow-up is necessary. For maintenance and proper functioning of the prosthetic leg, so it is advisable to him. Kindly follow the same in future. If there is any breaking in continuation of the follow-up, then he will be responsible for that. Will not take responsibility for the damage and malfunction of the.
And my lord, then your lordship will come to page 26, my lord. That is the Oil India, there where I am serving at present, my lord. By the doctors there. This is the only ground, my lord, which I am taking. They can place me
Lordship,
near the-
otherwise he is in Nunmati for 4 years, 11 months and in Guwahati for more than 11 years, Lordship. So otherwise also, Lordship, in page number 24, we have stated that Dibrugarh has a medical college and all better medical facilities are there, Lordship. But whether this Androlite, this is by senior prosthesis and branch manager. So he is a doctor or only a manager of the company. And
Now, what do you say about 28/3/2023, page 26?
Lordship.
That is the Oil India. Doctor.
When can you get your instructions?
Lordship, one instruction I have already received, Lordship, that is, Lordship, if we will allow him to stay in one place, that is affects the system, Lordship, that is there. But yes,
Understood, but you see, the person with disabilities have
Lordship.
got various rights.
right, Lordship.
Yeah.
But only that amputation part is there, Lordship. Otherwise, yes.
That is the only.
Yes, Lordship. And his annexure of this page 27 is that facility is available only in Guwahati, Lordship.
Then you can't help it, and if
Yes.
it requires
Yes,
regular
Lordship.
thing.
Yes,
So
Lordship.
I think you need to
Lordship,
inquire.
let it be this. He is directed to move on
31st.
on or before 31st. So let it come up on Monday, Lordship.
Monday you'll get it.
Let me try, Lordship. One instruction I have received, and better instruction I am waiting, Lordship. Otherwise, then Lordship have to stay. So let me try on Monday, Lordship.
Okay. At the request of Mr. Ms. B. Devi appearing on behalf of the central government.
B. Sharma.
B. Sharma appearing on behalf of the central government. Let the matter be listed again on Monday. Thank you.
Okay.
Obliged.
And in item 16.
Yes, Mr.
Extremely sorry, Lordship, my name has not been shown in cause
That
list.
is why I have asked him to call up.
Lordship.
Heard Mr. A. Azad, Mr. Azad Ahmed, the learned counsel sitting for the petitioner, Mr. Yes, who is appearing? Yes, Miss S. Burua. Where is she?
Government.
Mrs. S. Burwa appears for the respondent number 1. Mr.
Here, Gogoi Lordship.
Yagugoi appears for the respondent number 2, 3, and 4. What about 5? 5 also?
5 also, Lordship. 2,
Five.
3, 4, and 5, Lordship.
Issue notice making it returnable on. When did I fix the earlier matter?
Earlier matter, June, Lordship.
21st or 23rd of June I fixed it now.
Lordship.
Item 2. Item number
Item 12.
12 to
That was
22.
item 12, Lordship.
Have you done 23rd?
Lordship.
Issue notice making it returnable on 23rd of June 2023. July.
Lordship.
No, June.
June.
Can't
Lordship.
be July. 23rd of June 2023. 23rd is Sunday, July. 23rd of June. 23rd of June 2023. As the respondents are duly represented, extra copies of the petition be served during the course of the day. The case of the petitioner herein is that the petitioner is entitled to an amount of rupees 10,34,643 from the respondent housing board. The learned counsel appearing on behalf of the respondent housing board shall apprise this court on the next returnable date as regards the entitlement of the petitioner and as to when, and if so entitled, when the said amount would be cleared, disbursed to the petitioner.
Item 23.
Your matter?
Yes, my lord.
Yes, tell me. What do you want?
My lord, here the petitioner was initially appointed in 1996, my lord. Subsequently, he, my lord, appeared in the interview and he fared well also, my lord. And thereafter, his service was also regularized. Your lordship may kindly see the regularization order.
On 29/7/2000.
Regularization order is
Yes, Mr. Pukon, who is appearing for the elementary education department?
on 29/7/2000, my lord.
Yes, what is your instruction?
In this case, they have also filed the affidavit, my lord, and I filed my reply, my lord.
Then?
My lord, here, my lord, the petitioner was, service was regularized on 29/7/2000, my lord.
What do you want, madam?
My lord, here the petitioner was, his service was terminated by order dated 26 October 2005, my lord. Subsequently, my lord, 2005. Then in compliance of this, in 2005, and in the meantime, my lord, the petitioner filed a writ petition, my lord. And in the writ petition, there was an order whereby this termination order was stayed, my lord.
Stayed or set aside?
It was stayed, my lord.
Madam, you are ready or not? There are a lot of other lawyers waiting. If you are not ready, don't.
Received the file just now, my lord.
Oh, it's a matter. After 3 weeks.
'29.
Yes, Mr. Mary.
Please, sir. I did release my pensionary benefit and service benefit.
Yes,
All-
why
all
have
the
you fixed
respondent
this matter at 2 o'clock?
On last second listed on 22nd of May, my lord. On that
Yes,
day,
why
due
have I asked this matter at 2 o'clock today?
No, my lord, on that day, due to non-availability of time, my lord, could not be taken, my lord.
Hmm.
And all party are ready, my lord, because my lord, response number 8 is the my lord, second wife. She is also
Oh,
consented.
that day, you
Yes.
say that you are ready.
She is also consented, my lord. Department is also my lord, ready to my lord, give my lord, as per my lord. Provision is my lord, CCS pension rule 54(7)(b).
What does it say?
My lord, if the my lord, children from the first wife, if not measured, and the second wife is available, then it will be divided equally, my lord.
So this is as regards the pay the due amount of 7,61,000 in equal shares with the private respondent number 8, which is the legitimate. We are only concerned with 7,61,000.
Subsequently, the other pension, monthly pension also, my lord.
But that is not the prayer here. Where is the prayer? Amounting to rupees 7,61,000 excluding pension benefits in equal share. This is the prayer. When TPS pension rules is the decrease in the government savings in the pension. Left behind eligible children.
No, then-
The life. Do you contemplate payment of two pensions? Means division.
My lord, yes, my lord.
Where?
50.
Where the family pension is payable to more widows than one, the family pension shall be paid to the widows in equal share. So you are on that.
And first widow, my lord, died, my lord, her my lord, children, my lord.
They are entitled to.
Yes, sir. Up to the age of 25 years, the girl, my lord.
Becomes eligible for family under this rule from the date she gets married.
Once they get married, then the second wife will get married. The children will, if attend the majority of 25 years girl, then the second wife will get. Till then, my lord. And they have also consented that they have no objection, my lord. Response number 8, the second wife. We also filed the affidavit. We have also stated the same stand, my lord.
Pooja Harijan. She's 35 years, 25 years.
My lord, she will not get, her sister will get, my lord.
No,
And one brother.
daughter, who is it? Becomes ineligible under the daughter except a disabled daughter. Or a daughter becomes ineligible for a family pension under this rule from the date she gets married.
Vishnu Harijan, Monica Harijan.
No. Why are you saying the Pooja Harijan won't get it?
No, Pooja earlier got, my lord, she become 25, she will not get, my lord.
No, where is the 25 business of? Yeah, in case of unmarried daughter, until the attains the age of 25 years or until she gets married, whichever is earlier. So she won't get it. Petition number 1 goes. Monica Harijan is 24, she will get it. Vishnu Harijan, will he get it?
Yes, my lord, he is son.
17 up to 18, my lord, he will get.
Son is also 18, 25.
25.
The son will get it. These are the 3 people.
My lord.
I think 2 will get it.
Yes.
2 and 3 will get it. And
Question number 8 is Arati Ravidas.
is the first wife?
No, she is the second wife. She is the second wife, but in the pension, all the service record, her name entered. The disease entered her name.
Nominee, as
No,
nominee.
as nominee.
As nominee.
Okay, her dear name A.R. Mehdi.
Yes.
The learned counsel appearing on behalf of the petitioner. Mr. K. Parasar, K. Parasar appears on behalf of the CGSC. And your name?
R. Kumar, Your Lordship. R. Kumar.
R. Kumar appears on behalf of the respondent number 8. The instant writ petition has been filed by the daughters and son of late Jawahar Lal Harijan. Did he get his pension at any point of time?
Yes, my lord, 50% already get by the petition number.
Puja
one,
origin
my lord.
already get.
Did
Is it-
your father get it?
No, my lord.
No.
He had died on duty, my lord.
During duty.
During duty.
So and so. The petitioners herein are the sons and daughters of Jawaharlal Harijan, since deceased. The said late Jawaharlal Harijan expired on 28/6/2014 while on duty. Thereupon, the family pension was enjoyed by the respondent number 8.
No, not yet. Respondent number 1. She didn't came forward. Subsequently, only she came forward.
Who was enjoying
Puja origin.
I am enjoying 50%, my lord.
at that point of time?
At that point.
Yes.
Subsequent thereto, then why have you filed the case?
Lordship,
So
not.
when she came, department stopped it.
Then
Because
now department is not giving to anybody.
No, because of the this complexity, my lord.
Upon the death of the father, the petitioner number 1
Puja origin.
Puja origin.
was enjoying the family pension. As at that relevant point of time, she was an unmarried daughter and was below 25 years. Subsequent thereto, the respondent number 8, who is the second wife of late Jawaharlal Harijan, filed an FIR. He filed an FIR.
No.
FIR was regarding different matter, Your Lordship.
He approached the authority on 14 January
Approached the
2021.
authority on
14 January 2021.
14th of January 2021, claiming family pension. At that time, the concerned respondent authorities stopped the family pension. It is also relevant to take note of. What about these assets, this amount, 7,61,000?
My lord, now.
Is he entitled to?
No, that is except the pensionary benefit.
Are you entitled to this?
Yes, my lord, that is a service benefit.
That will be also 50-50.
Now, this amount is admitted.
Equally divided, my lord. That is 10,58,000, my lord, according to department, my lord. They have filed their affidavit in page number 63, my lord. Here affidavit.
Entitled to family pension.
Now, gratuity, matlab page 63, we have calculated 10,58,000
Total.
total.
Yes, my.
Page 63.
Page 63.
Now this is the entitlement.
Yes, now.
Last time কি লিখিলে তার আগতে that the petitioners herein along with the respondent number 8 are also entitled to an amount of rupees 10,58,698 as has been admitted by the respondents in their affidavit. Filed on 28/10/2022 at paragraph number 15. It has been brought to the attention of this court that Rule 54 7B stipulate of the Central Civil Service Pension Rules 1972 stipulates that when the deceased government servant or pensioner is survived by a widow but has left behind eligible children, child or children from another wife who is not alive, the eligible child or children shall be entitled to the share of the family pension which her mother would have received if she had been alive at the time of the death of the government servant or pensioner. In that view of the matter, the family pension has to be split on one half between the petitioner number 2 and petitioner number 3 till they are entitled to in terms with Rule 54(6) of the said rules of 1972, and the remaining 50%, the respondent number 8 would be entitled to. In similar vein, the amount of rupees 10,58,698 has also to be divided equally between the petitioners herein, because here I think the petitioners, huh?
Yes.
Because final, I think these are everybody will get it.
Yes.
Between the petitioners and the respondent number 8 in the ratio of 50:50. Accordingly, this court therefore disposes of the instant petition with a direction upon the respondent authorities, more particularly to
Exponent number 3. 3 and 6, madam.
respondent number 3 and 6 to disburse the family pension, including the areas in the family pension, in the ratio of in equal ratio, in the ratio of 50:50 between the petitioner number 2 and 3 on one hand and the petition respondent number 8 on the other. The said respondents are further directed to pay the amount of rupees 10,58,698 to pay the amount. Pay 50% of the amount of rupees 10,58,698 to the petitioners, and the remaining 50% of the said amount to the respondent number 8. The same should be done within a period of
2 months, my lord, at least.
2 months from the date a certified copy of this order is served upon respondent number
My lord, 6.
6.
My lord, more particular, my lord, respondent number 2, 3, and 6. My lord, 2 is the principal
3.
controller, 2 and 3.
I have to rise early today. There is a meeting